Good morning, everyone. Mr. Haddad,
Yes,
good
sir.
morning.
Good
I
morning.
was I received your announcements for today, but I don't have the full announcements for everyone. I didn't know if you all had those or not.
We do, Judge. The email, unless it messed up, I included mine and McLean, Mr. McLean.
I think he's on my company.
Oh, so there's also a whole bunch of conflicts, Judge. I'll forward you the email. I mean, there's a lot of conflict cases.
Oh, okay, maybe because
I-
okay, that might be it. Thank you.
Yeah, I can forward you the email, Judge, if you'd like. I sent that to Ms. Lewis and Mr. Jordan, just because it was an unusual number of conflict cases.
Okay, very good. Thank you. I appreciate that. So someone will print it out for me. I understand that we have it. Thank you.
And next time I'll try to remember to include it.
You're fine. You're fine.
0, 6, 5, 6, 7.
Right.
Where we do that. No, it's 6, 0, 3, 6, 5, 6, 7, 1. So that's the one you have to attach. You need to verify. 893, 54.
Without.
We're having some technical difficulties on this end. Getting Ms. Lewis onto the computer. We'll be ready to go as soon as we can get her logged on.
Hey, for Oconee County Jail, can you all put your phone number in the chat so I can give you guys a call and speak to Dion Anderson?
Usually they enter their name number. They get right to you because they know who you are. You should be a.
Is there a coach for now?
Hmm?
Hey, is there a long distance?
Who?
For long distance, 706 numbers, I need to dial.
No, you just pick up and wait for.
You know the code? No, that's what I'm asking.
Oh, I got it. Yeah. Apparently you might have one of those. Oh, you got the number? Yeah.
Nobody in.
Not good.
Oh, very good. That's what you use? Okay, yeah.
Everybody's got their own.
Oh, yeah, I mean, I didn't realize that. Confused me. Hi, I'm going to reach Jim Anderson.
Okay, we're ready to go whenever you all are ready for us.
We're ready, Your Honor.
I'm doing my description.
Okay. So who do we have first?
We could go to position number 1, Mr. Otis Alexander.
Okay, good morning, Mr. McLean.
Good morning, Your Honor.
It's my understanding this is going to be a negotiated plea.
Yes, Your Honor. 1 is null pros, 2 and 3 are negotiated pleas.
So here.
Good morning, Mr. Alexander. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can place your hand down. Good morning, Mr. Ham.
Good morning, Your Honor. All right, as it relates to position 1, defense is correct. The state will move to non-pros on position 1. For position 2, 20 CR 0007191Y. For count 1, simple battery against a police officer. The state's recommendation is 12 months, served 20 days, credit for the time served 10 days, the balance to be served on probation. To complete 8 hours of anger management, and also to complete 40 hours of community service. Count 2, disorderly conduct. The state recommendation is 12 months, served 20 days, credit for the time served 10 days, balance probation, balance to be probated, to complete an OP21 course, and to stay away from modern. For position 3, 20 CR 0031883Y, simple battery family balance. State's recommendation is 12 months, served 20 days, credit for time served 10 days, balance to be served on probation, to complete a family violence intervention program, as well as 40 hours of community service, to have no further contact with Catherine Kendall, and to stay away from 1107 Arrington Avenue in Atlanta, Georgia. Just for the states, just for the judges notice, we were able to reach the victim in position 3, and she does agree with this plea agreement, and she wishes no further contact with this defendant.
Okay, so it's my understanding that he's to have total of 80 hours of community service. Is that the intent?
Yes, Your Honor.
Okay. Mr. McLean?
Yes, Your Honor, that is what we discussed. We went over all the details. It's signed up and ready to forward. He asked that the court accept his negotiated plea of guilty.
Mr. Alexander, it's my understanding that in case 20 CR 0007911, you wish to plead guilty to simple battery against a police officer and disorderly conduct. And in case 20 CR 0031831, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Alexander. Let's see, when you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you get the anger management and community service done, the sooner you won't have to be actively report to probation, okay?
Sure.
Good luck to you, Mr.
Does
Alexander.
the state know, is there a particular topic? I mean, the Operation 21 course, sometimes we state what the topic is of the course. Is that one on general knowledge of the legal system, or is that a different course?
General knowledge.
Okay, anything?
We didn't stipulate, Your Honor, for the purpose of the plea, we stipulated the three necessary elements.
Okay. All right, good luck to you, Mr. Alexander.
Excuse me, can Tina, Chris, please put your device on mute?
Go there and cut it off.
We could go to,
Clerk's office.
position number 36, Mr. Derek Rogers.
Can Tina, Chris, can her device be placed on mute? Thank you.
And this is going to be a non-negotiated plea.
Yes, Your Honor, we're essentially requesting just a no probation. I can explain that at the appropriate time, Judge.
Okay. 36. Good morning, Mr. Rogers. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
I do.
Can you raise your right hand for me, please? Do you swear affirm that testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down. Thank you, sir. Let me go ahead, Ms. Tyson, good morning, and get the history.
Good morning, Your Honor. One moment. Give me one moment. I'm having trouble pulling it up. Just give me one second.
Yeah. Connie's talking. Something didn't clear. Here we go.
Your Honor, it looks like he has 46 arrest cycles beginning in 2007. His last arrest was August 7th of 2023 in Athens, Clark County. That was for a misdemeanor. It looks like a misdemeanor violation of probation and a criminal trespass that he took a NOLO plea on August of 2023. Let's see. He does have a failure to appear from 2023. Two failure to appear from 2023. At least 3 violations of probation in the last 10 years. He has a misdemeanor conviction out of Athens, Clark County for willful obstruction. Disposition date on that case is June of 2023. He has another misdemeanor conviction for willful obstruction out of Athens, Clark County from July 2022. Looks like he may have an open pending case in Athens, Clark County. Arrest date was May 10th of 2022, and that was for possession of methamphetamine. No disposition is listed on the GCIC for that case. He has another misdemeanor conviction out of Clark County for criminal trespass from July of 2022. It looks like he has another pending out of Clark County. Arrest date was August 13th of 2021. And that was for possession of a Schedule II controlled substance, 2 counts, and criminal trespass. Disposition states that the case was accused March 17th of 2022. No other information is provided on that case. Let's see, he has an additional, another misdemeanor conviction out of Oconee County, willful obstruction and theft by shoplifting. Disposition date on that case is February of 2023. He has another misdemeanor conviction out of Athens, Clark County for violation of family violence order. Disposition date on that case is March of 2018. He has a felony conviction out of Clark County for terroristic threats and acts, 2 count. Well, I'm sorry, felony terroristic threats and acts, 1 count, and 1 count of misdemeanor terroristic threats and acts. Disposition date on that case is May of 2018.
Okay, thank you, Ms. Tyson.
You're welcome.
Good morning, Ms. McConkey.
Good morning, Your Honor. In this particular case, the defendant is accused of stealing $324 worth of items from the Home Depot located on Piedmont Road. The defendant stole a Ryobi drill, 2 packs of batteries for the drill, and a pair of construction gloves. I also see that he has a 2018 theft by shoplifting conviction. The state's recommendation is 12 months to serve 44 days, credit for time served 22 days, balance probated, stay away from all Home Depot locations, an anti-theft course, and a $500 fine.
Okay. Yes, Mr. Dodd.
Your Honor, on behalf of Mr. Rogers, we stipulate as far as a factual basis, identity and venue, Judge, for purposes of the plea. The issue really, Judge, with Mr. Rogers is he is from Athens, Clark County. He's got a hold from Clark County. He's also got a hold from Oconee County. I mean, I'll be honest with the court. I'm not sure when his release date is. He's also has, residential issues and employment issues since he's been in custody. He's been in for 22 days. Under the circumstances, Judge, that's why I'm asking to essentially sentence him to time served so Clark and Oconee can come pick him up and he can deal with those issues. Because honestly, I don't know when his release date is going to be. And under the circumstances, I would ask for time served, balance suspended with a stay away from all Home Depot stores.
Okay, anything further?
No, Judge.
All right. Mr. Rogers, it's my understanding that in case 24 CR 003682C, you wish to plead guilty to theft by shoplifting. Is that correct?
Right.
Are you under the influence of any drugs or alcohol this morning?
That's right.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you've given up your right to a trial by jury?
I understand.
Has anyone forced or coerced you to plead guilty?
That's right.
Mr. Haddad, has he been in for 22 days on this charge solely on this theft by shoplifting?
Yes, Judge.
All right. The court sentence is 12 months to serve 44 days, credit for time served 22 days, balance suspended, stay away from the Home Depot. And good luck to you, Mr. Rogers.
Thank you.
Thank you, Judge.
Who do we have next?
We can go to position number 33 through 34, Christopher Potts. Prosser. Prosser. 34.
33 and 34. These are negotiated plea
Yes, Judge.
and a null pros. Good morning, Mr. Prosser. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Good morning, yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down. Thank you. Yes, Ms. McConkey.
Yes, Your Honor. The state's recommendation for position 33, Loiter Prowl is 12 months, served 48 days, credit for time served 24 days, balance suspended, stay away from the incident location, which I have as 11080 Old Roswell Road in Roswell, Georgia, and the state will null pros his FTA.
Mr. Dad.
Your Honor, we stipulate to identity, facts, and venue, Judge, and we'll just ask the court to follow the state's recommendation.
Mr. Prosser, it's my understanding that in case 23 CR 001618H, you wish to plead guilty to loitering and prowling. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with his representation? Do you understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No,
I'll accept the plea as negotiated. Good luck, Mr. Prosser.
thank you.
Thank you, Judge.
Who do we have next?
In position 37, Jaquel Spalding.
Also a negotiated plea.
Yes, Judge.
No, actually, what I told you is.
I apologize, Judge.
No, just let me know when you're ready.
So you've been released. I get off. I'm missing out work.
Judge, if we can just postpone this for a second, Judge.
Okay, let me know where you all like to go.
All right.
We can do, Ms. McLeod's client, which is position 24 through 29, Mr. Dontavius McCary.
Good morning, Your Honor.
Good morning, Ms.
I-
McLeod.
Good morning. I have not yet had a chance to speak with my clients. So I would have to speak with Mr. McCrary first.
Okay,
That's
So-
fine. You Speak about quorum too. You have the number, Ms. McLeod?
I have a number for the jail. I don't know. I've been calling, so I don't know if it's the correct number. This is the one I have saved. So you want to tell me which one I should call?
Let's see, 22391. 22391. We're about to call you, Ms. McLeod.
Okay, great. Thank you.
We can go to position number 11.
which position?
11 through 12. Deontay Graham.
And this is a negotiated plea, is that right, Mr. McLean?
It is, Your Honor.
Hey, good morning, Mr. Garnham. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. Can you raise your right hand for me, sir? Do you swear or affirm the testimony you're about to give before this court to be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Mr. Ham?
Yes, Judge. For position 11, state's recommendation, for position 11, the charge is death by receiving stolen property. The state's recommendation is 12 months to serve 32 days, credit for the time served 16 days, the balance to be served on probation. While on probation is the defendants to complete a theft prevention course, to complete 40 hours of community service, and to stay away from the Georgia State University campus, the entire campus. As it relates to position 12, the state will move to null par stat.
Mr. McLean?
Your Honor, for the purposes of the plea, we stipulate to venue and identification and factual basis. That those are the terms we expected to hear, yes.
Okay. Mr. Garnham, it's my understanding that in case 23 CR 005553B, you wish to plead guilty to theft by receiving stolen property. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir. I just
You
got one question
You've
though.
been represented by counsel. Are you satisfied with his representation?
Yeah, but it's one thing I gotta say. My job is literally, I work at Big Days on Foresight, so it's like I work right there by Georgia State, and so it's like it really nothing knocking. Until we move, cause we finna move to Centennial, right there by the old Waffle House on Centennial. So it's like I really want to have no way around Georgia State because my job is surrounded by Georgia State.
Okay, so you work at the,
Big
which,
Days.
which Waffle House do you work at?
Nah, it's a Waffle House that got burnt down on Centennial, but that's what we finna move to. But right now, our normal store is right there on Foresight. Like right there by, literally right there by Georgia State.
Okay, and what's the name of the business?
Big Days Philly Cheesesteak.
Your Honor, I'm familiar with that store. Big Dave's Philly Cheesesteak is on a public street, which is Forsyth Street. There are public sidewalks. Georgia State buildings are all around, but that particular store, you can get off at a MARTA station, walk down the sidewalk, and walk in the front door.
Okay, so I'm not gonna keep you from going to work, Mr. Garnham. If you have to, you can go to and from your work location. I'm not sure.
That's all. Cause we moving in August, so that's all I need to know.
Okay. I think my last question to you was, you've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that you're giving up that right by pleading guilty. You understand that?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated. Mr. Garner, when you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation, okay?
Yes, sir.
All right, good luck to you, sir.
Thank you, Your Honor.
Who do we have next?
Well, I'm ready back.
We could, go to position number 40 through 41, Jeffrey Walker.
And this is a negotiated plea.
It is, Judge.
Okay. Good morning, Mr. Walker. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
I do.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court to be the truth, the whole truth, and nothing but the truth?
I do, sir.
Okay, you can place your hand down. Thank you, Mr. Walker. Ms. McConkey?
Yes, Your Honor. For position 40, the state's recommendation is time served. The defendant has served 14 days and the state will no pros his FTA, which is position 41.
Mr. Dad?
Your Honor, we stipulate as far as identity, facts or factual basis and venue, would ask the court to follow the state's recommendation.
Mr. Walker, it's my understanding that in case 21 CR 007045J, you wish to plead guilty to criminal trespass. Is that correct?
I do, sir.
Are you under the influence of any drugs or alcohol this morning?
I am not, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
I am satisfied.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
I do, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Walker. Good luck to you.
Thank you, sir.
You're welcome.
Your Honor, I have a question about position number 6, Mr. Kurt Berry. We had, handled this case last week
He took a plea already.
on the full sheet again.
He took a plea already.
Ms. Lewis is saying that he's already taken a plea, so
We don't need him. It was just calendar in the air.
What did you
Okay.
say?
He already took a plea.
He's on by mistake, I think.
Okay. We can go ahead and go to, position number 38, Christopher Strong.
did you get a chance to interview him, Mr. Haddad?
Yes, Judge, I'm sorry, yes, I did this morning.
Okay, and what are we doing with Mr. Strong this morning?
And, Judge, that's gonna be a negotiated plea, Your Honor.
Okay. Good morning, Mr. Strong. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you. Yes, Ms. McCockey?
Yes, Your Honor. The state's recommendation is 12 months, served 30 days, credit for time served 3 days, an FVIP, no further violent contact with the victim, Shaquita Williams, and 40 hours of community service.
Mr. Dad?
Your Honor, we stipulate as far as factual basis, venue, and identity, would ask the court to follow the recommendation. And just for the court's information, I believe the victim is on for this, on Zoom. I just want to let the court be aware of that.
Okay, and what's the victim's name? Is that Ms. Strong here?
Yes, Judge.
Yes.
Okay, yes, good morning, Ms. Strong. If you would like to say something to the court, I'm happy to hear it. Of course, you're not required to. Is there anything that you'd like to say to the court? If you would like to say something, I'm gonna have to swear you in, okay?
Okay.
Okay, can you raise your right hand for me?
Uh-huh.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. What would you like to tell the court, Ms. Strong?
I have reached out to Mr. Hollis. I think his name is Mr. Hollis, and Ms. Cook, and gave them an update about everything. I want my husband to come home. I want the stay away order to be dropped because me and my husband have children in the house. We are newlyweds. We have a 3-month-old being the youngest, and we miss my husband home. We work well together as a team. The situation that happened wasn't major. My husband is not violent towards me. He is a good husband, and he is a great father. So him being away has hurt us more than it has done us any good.
Okay, so the recommendation is to have no further violent contact with you, so he will be able to return home.
Okay.
Okay, anything further, ma'am?
No, that's it. Thank you.
All right, thank you for being here today.
Okay.
Yes, Mr. Dad.
No, nothing to add, Judge. I would just ask for the, it's a negotiated plea, Judge. He's got a couple other issues, gonna be in custody for until next week anyway, so.
Okay. Mr. Strong, it's my understanding that in case 24 CR 002295D, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
One second. Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Strong. Let's see, when you complete the terms of the probation, I'll have it go to a non-reporting status, okay? So the sooner you get it done, the sooner you won't be on reporting probation.
Thank you.
Thank you, Judge.
All right, good luck to you, Mr. Strong.
Thank you.
You're welcome.
Next, we can go to 22 to 23. Mr. Charles McClyde.
And he's probation, Dion Anderson. I'm ready on him too, so.
Good morning, Mr. McClyde. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sir.
Thank you. You can place your hand down, Mr. McClyde. Ms. McConkey?
Yes, Your Honor. For position 22, theft by shoplifting and criminal trespass, the state's recommendation for count 1 is 12 months served, 24 days, credit for time served 12 days, balance probated, a $500 fine, an anti-theft course, and for the defendant to stay away from all Walmart locations. For count 2, criminal trespass, that is going to be 12 months and it will be concurrent with count 1. For position 23, theft by shoplifting, the state's recommendation is 12 months served, 24 days, credit for time served 12 days, balance probated, anti-theft course, restitution to the victim, Bridget Michelle Burton Williams, no further contact with Ms. Williams, stay away from the Quick Trip located at 4745 Jonesboro Road, and that will run concurrent with 24 CR 00405H. And I might have misspoken. I think position 23 is a theft by taking.
Okay. What is the restitution for, and what's the amount of the restitution?
The restitution is for Ms. Williams's Android H65 and HD65 Plus. I believe those are phones. Let's see. Actually, at this time, I do not have an amount for those items.
When is the last time the state reached out to Ms. Moore?
We reached out to Ms. Moore recently, but we have not had an opportunity to speak with her.
And why is that?
We have not been able to get in contact with her.
Okay, you've left messages and she hasn't returned the calls?
That is correct, Your Honor.
Okay. Thank you. Mr. Haddad?
Your Honor, I would, we stipulate as far as factual basis, identity and venue, Judge. We'd ask the court to accept the negotiated plea with the caveat. I don't know at this point whether the court would just not order any restitution, but I understand if we do, then we'll have to schedule for us restitution hearing, Judge.
Given that the state's reached out and the victim has not been in communication, if she wants to pursue it, she can pursue it in a civil manner. I'm not going to accept a plea where he doesn't know how much he's going to have to pay for these funds. It would make it could be quite costly, and if she had wanted it returned, I think that she would have been in touch with the state. So I'm not going to order any restitution. Okay.
Understood, Your Honor.
Thank you, Judge.
All right. Anything further before I take the plea?
No, Judge.
Mr. McClyde, it's my understanding that in case 24 CR 00405H, you wish to plead guilty to theft by shoplifting and criminal trespass, and in case 24 CR 00406H, you wish to plead guilty to theft by taking. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea. Please, as negotiated, Mr. McClyde. Once you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation, okay?
Thank you, Judge.
All right, good luck to you, Mr. McClyde.
Thank you, Judge.
We can go back to, position number 37, Spalding.
Okay.
Your Honor, I had additional time to speak to my client. We're changing it to non-negotiated plea, Judge. The only bone of contention is we're asking for time served. The state's recommendation is an additional 6 days, if my math is correct. So that's what the issue is, Judge.
Okay,
We do stipulate as far as factual basis, Judge, identity and venue. But of course, I leave it up to the court, whether it wants to hear everything.
okay. I'm not sure if I've already addressed Mr. Spalding, so let me go ahead and do that. Good morning, Mr. Spalding. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you. Ms. Tyson, are you able to give me Mr. Spalding's history, please?
There's 20 arrest cycles, let's see, beginning in 2015. Like we have a,
And it gets to us when.
15, 20.
misdemeanor conviction out of Chatham County for theft by shoplifting and willful obstruction. That's from November of 2018.
Maybe it is for.
He has another misdemeanor conviction out of Chatham County for theft by shoplifting, 2 counts of willful obstruction. That's from December of 2018. Another misdemeanor conviction out of Chatham County for theft by taking, willful obstruction from April of 2019. Another misdemeanor conviction out of Chatham County for marijuana possession less than 1 ounce from March of 2019. We have 1 violation of probation.
It was number 889.
Another, we have a felony conviction out of Chatham County for theft by shoplifting and misdemeanor willful obstruction. And that's from September of 2020.
Yeah, that's what I'm saying, and I'm not gonna call it as a fair restraint. Because
We have another misdemeanor conviction out of Chatham County for giving false name, carrying a weapon without a valid license, first offense. I'm sorry, and felony theft by shoplifting, and that's from September of 2020 as well.
They going by the
We have another misdemeanor conviction out of Chatham County for carrying a weapon without a valid license from September of 2020. And it looks like we have another felony conviction out of Chatham County for entering auto, willful obstruction of law enforcement officer, 2 counts, and theft by receiving stolen property. Disposition date on that case is September of 2020 as well. He received first offender treatment on that case, and his first offender was revoked in October of 2022. We have a PI conviction, first or second conviction, and that's from October of 2020. We have another felony conviction out of Chatham
I'm
County.
just letting you know, I'm not, it's not restricted.
And that's for theft by taking, theft by receiving stolen property, receipt, possession, or transport or found by convicted felon, giving false name, false statements or writings, conceal facts or fraudulent documents in matters of government, and possession of Schedule II controlled substance, and forgery in the second degree, and that's from October 2022. And he may still be on probation for that case. It looks like he received 2 years confinement, 3 years probation on that case. And his last arrest was in Chatham County, May 19th of 2022. Looks like that was for a violation of probation. He received 2 years confinement on that violation of probation, Your Honor. Nothing to add.
Thank you, Ms. Tyson. Ms. McConkey?
Yes, Your Honor. In this particular case, the defendant is accused of intentionally making contact with Nia Drone's buttocks without her consent. The state's recommendation given the defendant's history, including that PI conviction from 2020, is 12 months to serve 46 days, credit for time served 17 days, balance probated, and SDET, and no further contact with the victim, Nia Drone.
Mr. Dan?
Your Honor, on behalf of Mr. Spalding, he has been in custody since the date of arrest on this case, which is June 16th. My client requested a time served. There's no issues as far as the other conditions. He reports to me that he is employed as a forklift operator and is afraid he's gonna lose his employment. That's essentially my client's request, Judge.
Where's this job, Mr. Dad?
All right, it says it's Andy Company, it's right off Piedmont Road, Judge.
And what does he do there?
He a forklift operator, Judge.
Okay. I don't want him to lose his job. I can give him time served with an additional 50 hours of community service if he wants to do that.
That'd be fine, Judge. Thank you.
Okay. Anything further before I take the plea?
No, Judge.
Mr. Spalding, it's my understanding that in case 24 CR 003843Y, you wish to plead guilty to one misdemeanor offense. Is that correct?
No, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Was that a yes? I'm sorry.
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your plea, Mr. Spalding. The court sentence will be 12 months to serve 39 days. Credit for time served 17 days, balance probated, and SDET 50 hours of community service, and no further contact with Nia Drone.
Thank you so much, man.
Okay, I'm going to require that you be on probation for the entire 12 months, Mr. Spalding.
All right, thank you,
Good luck to
Judge.
sir.
Thank you.
Your Honor, we can go ahead and go to, Oconee
Okay, who do we have at the Oconee County Jail?
probation, probation revocation position number 1 and 2.
Okay, so this is this Mr. Anderson, is that right?
Yes, Judge.
Good morning, Mr. Anderson. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Good morning, Officer Allen.
Good morning, Your Honor.
Where are we with Mr. Anderson?
Well, actually, Mr. Anderson has 2 warrants. I'm not sure that the second case came up, but on 22 CR 0031933Y, the defendant was required to complete domestic violence counseling, have no contact with the victim. Again, he was charged with battery. The defendant failed to report to our office. The defendant was terminated from domestic violence on September 30th of 2023, where the defendant did in fact complete 2 of the domestic violence classes. It's 138 days remaining on his case. He's been in custody since June 2nd, 2024. And Your Honor, also on 22 CR 003194Y, defendant was also charged with the offense of battery family violence, where he was required to do domestic violence counseling as well as stay away from the victim in the case. Both cases ran concurrent. The defendant again has failed to provide our office with complete domestic violence classes. At this time, Your Honor, is 138 days remaining on both cases, and we ask for his balance to be revoked.
Okay. Mr. Dad?
Thank you, Judge. Judge, on behalf of Mr. Anderson, he has been in custody for 30 days now, Judge. He's 42 years of age. He was working as a chef, Judge, in Marietta. He reported to me that he had done about 4 to 5 classes. Then he broke his leg, which put him behind as far as employment, couldn't afford the classes, Judge. I mean, there's not enough time for him to do the classes now. I would ask the court, in light of the fact that he does not have any new charges, I would like to ask the court on his behalf to revoke him for 60 days, which essentially boils down to a time served sentence, Judge, and close out the case.
So where do you get the 30 days from, Mr. Dodd? I got that he has been in custody since June 22nd.
I apologize. I in my mind, I had it June 2nd, but I apologize. What the June 22nd is the appropriate time in custody, Judge. I misspoke and had the dates wrong. So
All right, so you're confusing me. That's why.
wow, that's good, Judge. I mean, my client is requesting honestly a time served sentence, Judge, but in light of circumstances, I would just ask the court to, instead of the balance, revoke something less than that.
Okay, so for both of the cases, I'm going to revoke 90 days. I'm going to require that he serve 90 days and close the case out, giving him credit for whatever time that he has already served. That's from, I guess, June 22nd until today.
June 2nd.
It is June 2nd.
Oh, it is June 2nd?
He's been in 31 days now.
31 days.
Okay.
So,
All right.
apparently.
So revoke 90 days, give him credit for whatever time he served, and close the cases.
Thank you.
Thank you, Your Honor.
Good luck to you, Mr. Anderson.
Thank you, Your Honor.
Welcome.
Awesome.
Who do we have next?
We have position number 5, Mr. Baker, here in medical.
Is that yours? No.
Okay, let's see. Is this one of
Yes, Judge, that's
Ms. McLeod's cases?
yes.
Are you with me, Ms. McLeod?
Yes, Your Honor. I have not been able to speak with Mr. Baker yet.
Okay, so why don't
I
we go?
sent a message to the jail saying the people I needed to speak to. I haven't spoken with them yet.
Okay, so why don't we place you into a breakout room? If that's okay with
That's
you?
fine.
Okay, so we'll place medical and Ms. McLeod into a breakout room if we can, so that they can discuss the case.
Thank you, Your Honor.
Okay. Is there anyone else that we can take while we do that?
Your Honor. Good
Hi.
morning.
Good morning, Officer Melton. I hope you're doing well today.
Awesome day.
Who do we have?
Natalia Evans.
Miss
Position number 9, I believe.
Okay. And this is going to be a negotiated plea.
It is, Judge.
Good morning, Ms. Evans. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir.
Can you raise your right hand? Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you, Ms. Evans. Mr. Ham?
Yes, Your Honor, for position number 9 on the calendar, for the count 1, simple battery family violence, state's recommendation is 12 months to serve 28 days. Credit for the time served 14 days, balance to be served on probation to complete a family violence intervention program, as well as 40 hours of community service. To have no further contact with Roderick Nixon and to stay away from 226 Anderson Avenue, Northwest Atlanta, Georgia. For the second count of simple battery family violence, the state's recommendation was 12 months or 28 days, credit for the time served 14 days, balance to be served on probation to complete a family violence intervention program, parenting course, and to have no further contact with Queen Evans.
Your Honor, I was not sure who the prosecutor was on this case. We're in agreement with everything with the exception with Queen Evans. And if I can explain, Judge, Roderick Nixon and my client have 2 children together. Ms. Queen Evans is not his daughter. So what transpired, Judge, is that my client, Natalia Evans, moved from Boston down here to visit with her 2 older children that are living with Roderick, and she was staying with Mr. Nixon when this incident happened, and of course she was arrested. So as of right now, Mr. Nixon, Ms. Evans, Queen Evans, the child.
I'm sorry, hold on one second. Mr. Ham, would you mind muting? Something's coming from your device.
Yeah.
Thank you.
Okay.
Go ahead. Go ahead, Mitch.
I'll repeat, Judge. So my client was staying with Roderick Nixon for the last few months, Judge, with 3 kids, 2 of which the oldest are Roderick's. The youngest, Queen, who's the victim in this case, is actually her daughter.
They're all my daughters. Sorry, I'm trying to be quiet.
Okay.
I'm sorry.
We're not disputing, they are your daughters, but I'm talking about Mr. Nixon. Mr. Nixon is only the parent of the father of 2 of the 3 of Natalia Evans' children. So what we're requesting, Judge, is a no further violent contact with Queen Evans because, you know, she's my client is the only parent. And we're also requesting a 1 trip for my client to be able to retrieve her belongings from the home, which will include her wallet, which contains a Bank of America card, and her cell phone, Jared. So in essence, we're asking for a time served sentence, the FVIP, the stay away from the residence, the stay away from Roderick Nixon, the parenting class, just to change it to no further violent contact with Queen Evans.
And how old is Queen?
I believe she's 12, 10?
She's 10.
10.
Am I allowed to speak? I'm sorry, I'm not trying to be rude.
Ms. Evans, you have a right to remain silent. Anything you say can be used against you. Mr. Haddad, would you like to advise your client? As far as Queen goes, is she living with Ms. Evans, or is she living with Mr. Nixon?
She is normally living with Miss Evans, my client, Judge. But obviously, since the arrest, Ms. Evans, the daughter has been living with Mr. Nixon.
And where is she going to live once Ms. Evans is out of custody?
So there was dispossessory issues prior to that, so my client was in the process of getting her own place, which she will once she gets out. So the plan is, Judge, is once my client is released from custody, she has a friend she can stay with. She's gonna complete the lease for her new apartment and then get her daughter to live with her.
Okay. So prior to this, who was Queen living with? Was Queen?
My client.
Okay,
So they were living in Massachusetts, Judge. They moved down in October, primarily so my client can see her other two kids that are living with Mr. Nixon, who's the father. So she ended up staying with Mr. Nixon. There were issues. There was this possessory filed, and unfortunately, there was this crime, Judge.
okay. All right, given that it's her child, I'll have her have no further violent contact with Queen Evans, and we can add a one-time escort to retrieve any belongings that she might have at the Anderson Avenue address.
And if I may,
Yes,
I
Mr.
believe
Henry.
the victim in this case indicated that he's the custodial parent, so I believe there may be some sort of already parenting plan in place. I would just ask that the court allow them to agree with whatever parenting plan the court has already set up in regards to the custody of the two children.
And I'm sorry, Judge, the two children of theirs, it's not the victim. It's not Queen Evans. These are, we're not addressing the older two. We're addressing just the younger, who's actually the victim in this case.
Well, there's gonna have to be some type of third-party transfer, given that she's to have no further contact with Roderick Nixon. And if he has the children, then there'll have to be a third-party transfer so that she doesn't violate the no further contact, right?
Understood. Yes, Judge.
Okay. So third-party transfer of any minor children, and if there is a parent, if there is a plan that's already in existence, then I'll just have her abide by whatever custody plan is already.
Could I say something, Your Honor, please?
Mr. Dad, I'm happy to have her chime. Yes, Ms. Evans.
I have my 3 kids live with him, so if I can't, all right. How am I gonna see my kids if I can't contact him? If I can't.
You'll have to have a third party, go through a third party since you can't have any contact with him. So you'll have to establish some type of third party to negotiate when and how you get your children.
Okay. Do I have to go to the courts for that, or?
No. It can be a family member. It can be whomever. You just can't have any contact with Mr. Nixon while you're on probation. Okay? You need to speak with Mr. Haddad about that?
You need to say yes or no, so the court will. We've discussed on these things.
No.
I mean, Sunday, Judge.
All right. I'm just trying to figure out how I'm gonna see. Okay, no problem.
Okay, so you'll have to figure that out, Ms. Evans, okay? But
sir.
I just want to make sure that you understand that you cannot, based on what has been negotiated between your counsel and the state, have any further contact with Mr. Nixon. And no contact, it means no contact
Is that what
whatsoever.
he said? He said no, he don't want to contact with me? Or is that what you guys?
Is that Mr.
I mean,
Harris?
I know the situation. Is that what he said? Or is that just?
Yes, Your Honor, that is actually his statement. He's actually said that the children are afraid of her and do not want to have any contact with her. But that's his statement.
Okay, so I'm not going to keep you from your children, Miss Evans, but given that Mr. Nixon doesn't want to have any further contact with you, I'm gonna honor that request. Okay.
All right, no problem, sir.
Okay. Anything further before I take the plea?
No, Judge. Thank you.
Ms. Evans, it's my understanding that in case 24 CR 003938B, you wish to plead guilty to 2 counts of simple battery family violence. Is that correct?
Yes, sir. Your
Are
Honor.
you, are you under the influence of any drugs or alcohol this morning?
No, I'm not, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes,
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
yes,
Has anyone forced or coerced you to plead guilty?
no,
Okay, I will accept the plea as negotiated. We will also change the no further contact with Queen Evans to a no further violent contact with her. I'll give you a one-time escort to retrieve any belongings from the Anderson Avenue address, third-party transfer of any minor children for visitation, and abide by any pre-existing custody plans. Let's see, once you complete the terms of the probation, Ms. Evans, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation, okay?
Can
All
you
right.
repeat that? I'm sorry. Say that again.
Once you complete all the terms of the probation, meaning that you do the 40 hours of community service, the FVIP course, the parenting class, then I'll have the probation go to a non-reporting status, so you won't have to actively report to probation once you get all the terms done.
Okay.
You
Does that,
understand?
yeah. Am I getting out today, right?
This is
that
a time, it's my
an
understanding
agreement?
it's a time served plea, so as soon as the jail can process you out, you'll be getting out as long as you don't have any holes, which I
Okay.
don't believe that she does she?
No.
Okay, anything further, Ms. Evans?
No, sir.
All right, good luck to you, ma'am.
Thank you.
Okay, who do we have next?
That motion carried? No. Do I have anything ready?
No, we're, waiting on Ms. McLeod to come back.
And this Lynch gonna be.
Lynch should be produced on jail.
Okay, so I guess we'll be in recess until someone is ready to go.
Yeah.
Your Honor, did the court get?
Yes,
Did the court get all the conflict cases?
let's see.
I can forward it to you if you need to, Judge.
I got them listed, Judge.
Okay.
They are. It's just that we just don't have a conflict of terms on the co-defendant. Just look at this.
Okay, yes, I do. I have it now, thank you.
I'm already on set here. Hey, Eddie, it's Mike. How's it going? Do we have Tanya Jones? something else.
Your Honor, Ms. McLeod is back.
So if there's any problem, he wants to go ahead and take all the time.
Okay, where would you all like for me to go now?
Let me know if that's a problem. I think
We can do her, position 24 to 29. Mr. McCary.
No one's drug use is a common brand.
Yes, 24. Ms. McLeod, you had the opportunity to speak with Mr. McCrary.
I have, Your Honor.
And what are we doing with his cases today?
Your Honor, my client would like to make this a non-negotiated plea if possible.
Okay, let's see. Good morning, Mr. McCrary. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your cases heard by video?
Yes, sir.
Okay. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. So let me just go through the charges first, Ms. McLeod, to see what is not negotiated, given that there are a number. Position 24, he's charged with battery family violence. And what will be non-negotiated about this?
Well, it appears the state wants him to serve 180 days, Your Honor,
Okay,
with credit for 15 days. And he wants to get out of jail because he has a 3-day-old child plus a 6-year-old for whom he's the primary breadwinner. And if he stays in jail, they're going to be evicted from their home. And everything is going to go south for those children, and that is his major concern.
okay. Position number 25, obscured or missing license plate. Any objections to the recommendation there?
No, Your Honor.
Okay. We have 26, 27, 28 of failure to appears. 29 is simple assault and disorderly conduct. Any objections to the recommended sentence on those?
No, Your Honor.
Okay.
Apart from the time in the first case, there is an objection to the no further contact with the alleged victim because the alleged victim is the mother of his 2 children.
Okay, so let me hear what it's about first. And Ms. Tyson, may I have Mr. McCrary's history, please?
Yes, sir. 22 arrest cycles beginning in 2009. Looks like he had a felony case out of Henry County for theft by receiving stolen property. He received first offender treatment on that case in 2014, and the case was sealed in 2019. Looks like his last arrest was, let's see, in Fulton County, December 26th of 2023 for a failure to appear. He has multiple failure to appears. He had 3 failure to appears in 2024 and 1 in 2023. 1 in 2014, 1 in 2013. Let's see. He has a misdemeanor conviction out of Fulton County for reckless conduct in 2019. Another misdemeanor conviction in Cobb County for theft by shoplifting in 2020. Another misdemeanor conviction out of Clayton County for simple battery, and that's from February of 2024. And it looks like he may have a possible pending case out of Fulton County for theft by taking and criminal damage to property in a second. No dispositions listed on the GCIC for that case. And a pending case out of DeKalb County for 2 counts of cruelty to children in the third. 1 count of aggravated battery. 1 count of simple battery family violence And it looks like one count of battery family violence. The case was indicted February 21st of 2024. Let's see, and he has a total of, let's see, two violations of probation. One moment here, I'm checking. And it looks like he had 2 cycles out of the state of Florida. Last arrest was June of 2015, and that was for, let's see, loitering, prowling. And let's see, it says public order crime offenses against a police dog. Case was null priced January of 2016. Nothing to add, Your Honor.
Thank you. Ms. McConkey?
Yes, Your Honor. For position 24, the battery family violence, officers arrived at the incident location and met with the victim, Courtney Powell, who stated that her and the defendant were having an argument that turned physical when the defendant struck her in the eye with his hand. There was a visible mark under the victim's eye. The state's concern is for the victim's safety, as he has a history of battery and assaults, and the police have been involved with the parties on more than one occasion. The simple assault disorderly conduct charge also involves the same victim. The state's recommendation for position 24 is 12 months, serve 180 days. Balance probated, no further contact with the victim, Courtney Blackwell. Stay away from the Georgia Tech Hotel. That is where the incident occurred, and that is 800 Spring Street in Atlanta, and an FVIP, and that again is for position 24.
Your Honor, and he does have a hold for DeKalb County as well.
Okay. Can we go to position 29, Ms. McConkey?
Yes, position 29, the simple assault disorderly conduct. Officers arrived at the incident location where they met with the same victim, Ms. Courtney Blackwell, who advised that the defendant had taken her wallet, which he proceeded to give back at the officer's instruction. The parties then got back into the vehicle and started arguing, and officers observed the defendant swing at the victim, and officers at that time had to intervene, and the defendant was subsequently detained. In this instance, the defendant attempted violence in front of a police officer, which is very concerning. The state's recommendation for count 1 is 12 months, serve 30 days, balance probated, no further contact with the victim, 8-week anger awareness, 40 hours of community service. For count 2, the state's recommendation is 12 months to run concurrent with count 1, and this will be concurrent with 22 CR 00851E.
Okay. Do you have the bond conditions on that case, Ms. McConkey, or do we have it, Ms. Lewis?
I can definitely get them.
Okay, I have, let's see.
That's 24.
That's 24, okay.
This is 24. 29 was not on a SEA counter, it was just on a regular SAP counter. Look that was on a SEA counter, on position 24. And I think position 25. Just a regular counter, so that was 20.
Were you able to get those bond orders, Your Honor? I'm still trying to find them.
That. You're gonna put it on the long wall right there. Hey. No. No. Come on. She's coming back. Okay. Hey, this is, Ms. Vaughn, Ms. Warren.
Oh.
Okay. This is back to the chair. Yeah.
Since June 1st. Past July. I'm going to county. Fill down and book my.
So they'll ask probation ask for 16 days left.
Who's Ms. Vaughn's attorney?
You both. But I'm gonna say there's why were you listening to the first one? You charges?
At all. I saw the officer and he told me why in the time he only on my record receiver had done. But
Okay, let's see if we're all back now, that the internet went down. And I don't see Ms. McCockey back with us, so,
So I'm here, Your Honor.
oh, there you go. Let's see, I believe when we went down that I was asking about the DeKalb. The DeKalb, do you know anything about the DeKalb cases?
No, I don't. I was not able to ascertain whether it was the same victim in that case. And unfortunately, our office has tried to contact the victim, Ms. Courtney Blackwell, but she has not gotten back to us yet. I was able to find the bond conditions for the position 24, the battery family violence, and it was no further contact with the victim and also to stay away from the incident location. And there was a second location there, which I believe may be the victim's home address. It was a 2151 Green Forest Drive.
Okay, thank you. And the recommendation of the 180 days, Ms. McCockey, what is that based on?
It's based on the defendant's history, which does have some violence, and also the fact that that violent history does is with the same victim in this case.
Okay. But we only know of, when you say the same victim, it's the simple
Yes,
assault
Yes,
back
Your
in,
Honor.
back in 2020?
Yes, Your Honor.
Okay. Yes, Ms. McLeod.
Your Honor, I do not believe that my client has a significant violent history at all. He does have some history. I believe that it was said that he has 22 cycles, but sitting here listening to what pretrial said, it does not sound like he has a significant violent history, and certainly not with this alleged victim. They've been together for a while. They have a 6-year-old child, and my understanding is they also have a very young child as well. 3 days old. Based on my conversations with him, he was under the understanding that their contact was no further violent contact, as opposed to no contact at all.
Okay, well, I signed this bond back in December of 2022 that states that it was a good bond, that he was to have no further contact with Ms. Blackwell. So with that being said, given that he has a 3-day-old child with her, there's obviously a violation of my bond order. I think what I'd like to do at this point, Ms. McCockey and Ms. McLeod, I would like to reset this case for next Tuesday when I will be on the bench. I would like for you to reach out to DeKalb County to see if that aggravated battery is against the same victim. And if it is, that will play into my decision. We have that theft by taking and criminal damage to property. I don't see why, if that's pending in state court, we should add that so that we can dispose of all of these at one time. Are you in agreement with that, Ms. McLeod?
Yes, Your Honor.
Okay, and also, Ms. McCockey, if you can continue to try to contact Ms. Blackwell to see what her wishes are.
Yes, Your Honor. Absolutely.
Okay, so let's reset Mr. McCrary for 7/9 next Tuesday. And given that the recommendation was on both these charges was additional jail time, I'd like some additional time for you all to investigate.
The state hasn't.
Ms. Blackwell.
Not taking charges yet.
Say it again.
The state hasn't been accused.
I'm saying I'm Ms. Blackwell.
Oh, Ms. Blackwell
is on. Okay, I was not aware that she was on.
Has a big C next to it.
Okay, so I still think that I want this. I want to figure out what's going on with DeKalb County, and it's my understanding that you all haven't accused those other 2 cases. Ms. McCockey, you probably need to go ahead and do that.
Which 2 cases were those, Your Honor?
I understand there's a theft by taking and a criminal damage to property.
Okay, we'll make
That's
sure to.
pending in state court, per pretrial. Okay. And I guess if you can have your victim advocate, get in touch with, or see what, Ms. Blackwell has to say to them.
Absolutely. And she is on the Zoom.
Yeah, she is on the Zoom. She's under, my understanding, Big C. Okay. All right. So, I'll see you back next week, Mr. McCurry.
Mr. McCreary, do you want to ask about your bond?
Yes, that's what
Yeah, well, because it's a FTA, they're not going to consider the issue of bond at all.
I went to court for these days. That's why I'm not understanding how I got 3 failure to appear and I went to court May 14th. There wasn't the court date that I supposed to went to court. They actually tried to train me saying I had went from Cobb County when I went to court. So how they saying I got 3 failure to appear? They had to call Cobb County after I got down to court because my lawyer wasn't there. That's the reason why she didn't see me, because she was like, my lawyer wasn't there. So
Okay. Well, it's my understanding that the failure to appears will be null pros if if a plea goes forward. So, Ms. McLeod, if you can speak with him about that within the next week.
Absolutely.
Okay.
I will.
Thank
Your
you.
Honor.
All right, Mr. McCray, I'll see you next week. And Ms. Blackwell, someone from the solicitor's office will be reaching out to you. And you're happy to be here next week if you choose.
Ms. Blackwell, check your messages. I sent you my phone number.
One row back.
So can we go to medical?
Position number 16, Harvey.
And this is your client also, Ms. McLeod?
Yes, Your Honor.
Okay, and what are we doing with
This is going to be an arraignment, Your Honor.
Okay. Position number 16.
The state has made an offer, but my client will not be accepting the offer. I am prepared, of course, to file a formal waiver of arraignment.
Okay, so if you file a waiver, Mr. Harvey, your case is going to be returned to the division judge. You'll get notification of your next hearing date, sir. Good luck to you.
We can go to position number 39, Ms. Akila Vaughn.
Okay.
And I still have some clients that I need to speak with.
Okay.
I sent a message to the jail.
So as soon
Mr.
as we have,
Harper, Mr. Kelly.
okay, so let me see. Where is position 39? Is he in courtroom 2?
She is.
She 39. And who do we have at medical?
Position number 5, Baker.
Mr. Baker.
Is this your case, Ms. McLeod?
It is, Your Honor.
Okay, so let's go ahead and place Ms. McLeod and medical into a breakout room, please.
She's already spoke to him.
Oh, you've already spoken to him?
I have spoken
Oh.
with him, Your Honor.
Okay, all right, so let me go ahead and do Ms. Vaughn. Good morning, Ms. Vaughn. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Ms. Vaughn,
Yes.
can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. It's my understanding that this is a negotiated plea, Mr. Dunn?
It is.
Yes, Ms. McConkey.
Yes, Your Honor. The state's recommendation is 12 months, served 30 days, balance probated, no further contact with Veronica Davis, 8-week anger awareness, and that is for count 1 battery. For count 2 cruelty to children, the state will be null prosing that charge.
And, I have a question about the cruelty to children. Y'all got it listed as a felony on our side. Are you guys gonna change it to a misdemeanor to report as a misdemeanor in all cross? Because I'm not supposed to report, process felonies.
Okay, I did not know listed as a felon.
it's in the system as a felony, cruelty to children, first degree. That's what you got on the calendar.
Yes, I will,
I know you're
Talk-
not passing it, but it needs to be changed to a misdemeanor instead of a felony. You see what I'm saying?
yes, absolutely. I will contact Deputy Falk to see what the process for that is, but I do think we will still be no crossing it.
Okay, that's fine. I just want to make sure it's reported as a misdemeanor instead of a felony. I don't know if it
Yeah.
makes a difference or not, but we're not supposed to report felony charges. That's fine.
Okay, Mr. Dodd?
Your Honor, we stipulate to venue factual basis and identity, and we ask the court to follow the recommendation, Judge.
Ms. Bond, it's my understanding that in case 24 CR 003657G, you wish to plead guilty to battery, is that correct?
Yeah, yes,
Are you under the influence of any drugs or alcohol this morning?
no,
You've been represented by counsel. Are you satisfied with his representation?
yes,
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
yes,
Has anyone forced or coerced you to plead guilty?
no,
I'll accept the plea as negotiated. Ms. Vaughn, when you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you get it done, once you get out, the sooner you won't have to report to, actively report to probation, okay?
Can they tell me how much time they're giving her credit for? Or they're not giving her a credit? She got to serve the whole 30 days?
All right, is there any credit for any time served?
No, I didn't see that she was in for this particular charge, that she was being held for this charge, so there's no credit for time served.
They still gonna hold her for 30 days. I'm just letting y'all know.
Okay, anything further?
No, Judge.
All right, good luck to you, Ms. Vaughn.
Position number 5, Baker.
Let's see, Ms. McLeod. What are we doing with Mr. Baker this morning?
This is also going to be an arraignment, Your Honor.
Okay, you're gonna
And I
follow.
will be filing a formal waiver of arraignment for Mr. Baker.
Let's see, Mr. Baker, your case will be returned to the division judge and you'll get notification of your next hearing date, sir. Good luck to you.
That's information knowledge.
Who do we have in medical?
Position number 7, and he said he did not speak to a public defender.
Is this your case, Ms. McLeod?
He had a private counsel and he fired his attorney, so he's present on last week.
What is his name?
Mark Chestnut.
No, not on my case, Your Honor.
There's a withdrawal.
His attorney withdrawal, but he just filed the paperwork the other day. His attorney withdrawal as counsel on the case, but it has not been signed off by the judge.
You can do it.
Okay, do you have the paperwork that I can sign off on it?
No. I don't.
Mr. Dodd, given that his counsel is seeking to withdraw, can I get you, I'll sign that order. Can I get you to speak with Mr. Chestnut?
That'd be fine, Judge. I'll speak to him if you want to put him in a breakout room. At the very least, I'll communicate the recommendation to him. If you need more time, we can reset it for next week. But
Okay, that's fine.
do that.
So do you all have anybody else in courtroom two with you?
I do, Judge. I have a probation violation case. That's the last one. She's here in the courtroom, Judge.
Okay, so why don't we do the probation case? So I've signed it? Or it's
Yeah, you
been
signed it
signed?
yesterday.
Okay. So Mr. Chestnut will be with you, and I apparently signed that order releasing his attorney yesterday. So this is Ms. Wararu.
Yes, Judge.
Okay.
Yeah, we can go to make this, it's 1:30, it'll see it live, but we don't get to.
Yeah, I put it right there. I think you took it.
Yeah.
Yes, good morning, Ms. Waruru. This is a probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Officer Allen, are you with me?
I'm sorry, Your Honor, I stepped away. I just walked back up.
Okay, you're fine. We're on positions 3 and 4.
Okay. All right. All right, Your Honor, the defendant was required to report to probation, complete a clinical evaluation, and once he completed that clinical evaluation, his case was to go non-reporting. He has failed to report to our office. He's failed to provide documentation
This
of the
is Miss.
clinical.
This is Miss Waruru. I just want to make sure that we have the right Margaret.
Margaret, yes.
Okay.
I'm
Okay.
sorry.
I guess you were confusing us because you were saying him.
Oh, my apologies. I
Okay.
think I threw myself off. So yes, she was required to complete a clinical evaluation as well as report to probation. She's never reported to our office. She's failed to provide us with that evaluation. Is 116 days remaining on her case. At this time, Your Honor, we ask that she be allowed to continue on to complete that clinical evaluation.
I'm the host.
It looks like the internet at the courthouse is going down. So I'm actually logged on through my cell phone because my internet still has not come up. So
Mr. Hamill, I have you here. Are you handling the Andrew Lynch matter, position 2021, or is that your?
nope, that's me.
Okay, I'm gonna send you a chat to explain. Well, I'll send you a chat now.
Does it have something to do with the community service? Is that the contention?
No, he's been in custody since he got arrested back in November. He was shipped to Douglas County and was brought back. So he's been in continuous custody since November 15th. And I've confirmed that. So I'm asking the judge for a time served sentence, basically. And otherwise, it'll be his bond gets reinstated because when he missed court, he was actually in custody in Douglas County. That's really why I'm asking for a non-negotiated plea. Is just that because he's not been out since he was arrested on this case. He got a signature bond sent over to Douglas on a probation violation, and he's been there ever since until now.
I mean, would you be amendable to
I mean, he's
balance suspended and just staying away from that location?
Yeah, that works. Yep.
Okay.
Perfect. Thank you.
No problem.
What? Hey, somebody made me host. Oh.
Been through that. Been through that. I like how.
It's gonna.
Jeffrey Walker. Clyde.
So they're asking to reinstate your probation.
And then go to, government. Okay.
132 Mitchell Street.
132, yeah, 132. All right. Okay, sure.
So I don't know why they made me the host. So there's 3 people in there waiting to be admitted. I don't even know who these guys are. You want me to let the bench warrant folks in? Mike? You want me to let the?
Yeah.
All right.
I can't reach Shelton.
Hey, Ms. Lewis?
And so.
I ended up being the host. Oh, yeah. Second.
He might start representing him or he might have.
Okay, let's see.
Do you know whether he plans to hire a lawyer?
Yes, Officer Allen, I believe. Would you mind starting your presentation over again for me?
Yes, Your Honor.
Thank you.
The defendant, she was required to report to probation for the charge of public indecency. She was required to complete a clinical evaluation. I'm sorry, she was required to complete a clinical evaluation as well as report to probation. She's never reported to probation. She's failed to provide our office with completion of the clinical evaluation. At this time, Your Honor, is 116 days remaining on her case. We do ask for, well, we recommend for her to be allowed to continue on probation.
What's the problem, Mr. Dodd?
Your Honor, I'll be honest with the court. Well, let me back up. My client has been in custody since June 1st. And yesterday, apparently she fell at the jail and broke her foot. Having her reinstated in time served, I think getting her out of jail is obviously the best thing for her. Your Honor, from speaking to my client, it appears that she's got some mental health challenges. So to answer the court, I think that might be part of the issue. I've talked to her about if the court is inclined on reinstating her, that she needs to report to probation at 132 Mitchell Street. I did not have any medication, Judge. She's on medication. I couldn't really understand, frankly, what type of med she's on, Judge, but that's part of the challenge.
Officer Allen, when she does report, do you give her where she needs to go to get this clinical evaluation?
Yes, Your Honor, we will. I guess I would have to ask, is she currently employed? Because that evaluation will cost.
Yeah, she mentioned she worked at a BP, but I couldn't get much after that. So I really don't know what that means.
And she has been in custody, Your Honor, since June. Actually, I'm looking at the booking screen. She's been in custody since June the 4th. And there's 116 days remaining on her case.
So since June 4th, how many days does that mean that she's been in custody?
28 days.
28, almost 30 days. I mean,
29 days as
Time served, 29 days and close the case.
Thank you, Judge.
All right. Good luck to you, Ms. Warwood.
Thank you, Judge.
Your Honor, that concludes my business. May I be excused?
Yes, we'll see you next time. Thank you, Officer
All right.
Allen.
Thank you.
Thank you, Judge.
Position number 7, Mr. Chestnut.
Okay, so you need to speak with Mr. Chestnut. Can we go into a breakout room now?
Yes, Judge. It won't take long.
Okay.
But I'm ready
So-
when the court is for me to join.
If we can place courtroom 2 and medical into a breakout room, and we will have to be in recess while they do that.
That's it.
Mr. Kelly, position number 18 and 19, they just say he's a conflict. So Ms. McLeod, can you talk to him, please, in a breakout? Position number 18 and 19, Mr. Kelly.
Yeah, Mrs. McLeod
Yes,
already aware of
this is to speak with him.
She's already informed him.
Okay, so you need to speak with him, Ms. McLeod, in a
Yes,
breakout?
Yes, John.
Okay, so if we can put medical and Ms. McLeod into a breakout, please. And did you have an announcement, Mr. Dodd? Courtroom's on mute if you're talking to me.
Sorry about that. Position number 7, Lamar Chestnut, will be a plea judge.
Okay,
He's requesting a NOLO plea judge. I told him if, either way, it's gonna work out as a plea under the terms suggested by the state.
okay, so he was in medical, is that right?
He was, Judge. I spoke to him. And then.
So we'll have to wait for them to come back online, I guess. While we're waiting, can we go ahead and handle the DV bench warrant calendar? Have you all had the opportunity to speak with those people, Mr. McLean?
Yes, Your Honor, all but Shelton, what's Shelton's name? All but one of them, yes.
Okay, so I believe that they're all on the line with me. So would you like to just start from the top and go down, and then I'll allow you to speak with?
That works for me. We're ready.
Okay. Let's see, who from the state is representing on the bench warrant calendar?
I have no attorney yet at the moment.
Okay, Ms. Amani, this is Ms. Candler, is that right?
Yes.
Okay, Mr. McLean, you still need to speak with Ms. Candler, is that right?
No, Your Honor, we've spoken to everybody but DeShante Shelton. We could not reach that person by phone.
Okay, so
I'm here though.
Okay, yes, sir, we'll get someone to speak with you. So Ms. Candler, it's my understanding that you did speak with Mr. McLean prior to this hearing, is that not correct?
Yeah, I've spoken to him yesterday.
Okay, all right, so I take it that she missed a court date, Mr. Ham?
Talking to me?
Yes, sir.
Okay.
What court date did she miss, Mr. Ham? I can't hear you, Mr. Ham, for some reason.
Can you hear me?
Something's going on with you. You might need to speak closer to it or something. I tried again. You're muted now. Go ahead.
Is this better?
Yes, it's a little better. Go ahead.
Apologize. I'm not sure what's going on with my audio today.
Okay. Okay, I can hear you now. Go ahead.
One second.
Okay, did Ms. Candler miss a court date? And if she did, what court date was that and in front of whom?
Yes, Your Honor. There was a plea arraignment that was before Judge Roth on April 6, 2022. A arrest warrant, FTA was issued at that time.
Okay. What's the issue, Mr. McLean?
Your Honor, when this happened, whatever did happen on January the 10th of 2022, upon making bond, I imagine that was pretty rapid, she went back home to Homewood, Illinois. She's been reporting to, I believe it's pretrial services, I get the impression. She says, I kept, whoever it was she was reporting to, she kept them apprised of her having moved back home, and she also changed her postal. Yeah, so she did two things right, but the one thing she didn't do was tell the clerk. She didn't know.
Okay. Ms. Candler, anytime you move or you need to inform the clerk, it's not the pretrial's responsibility to inform the clerk that you've moved, and that's how you get notice of your court hearing. So I give everyone one opportunity. This is your opportunity. I'll set aside this bench warrant, but you need to make sure that if you do move residences, that you update the court with your correct address, okay? So at this point in time, I'll set aside the bench warrant. Mr. McLean, if you can do that for the court, we'll get that signed.
Yes, Your Honor.
You'll get notice of your next hearing date, Ms. Candler.
Okay, thank you. So sorry about being negligent and not updating my address on. It was a moment.
All right, I just want you to get pulled over, and what if you got pulled over, you'd have a bench warrant out there for you, and then they'd arrest you. So I don't want that happening to you. Okay.
Yeah, me neither. Me neither. Thank you so much.
All right. So all right, you have a good day, Ms. Candler.
Thank you. You too.
Position number 2 is Rachel Harvey.
Yes, Your Honor. When I spoke to the phone, when I called the phone number, I got her mom, and her mom said, you know, my 2 daughters were having an argument. I wanted to do a 1013. The police instead made an arrest. There was a actual 4-digit number, and the 4-digit number that appears on the address to which the notice was apparently sent ends in a 6. Their house ends in a 4. There is no house that ends in that 6 because it's just, I don't know what the source of the mistake is. I don't know why they didn't have the correct. I haven't looked at anybody's driver's license. I haven't looked at anybody's ID card to see if that was mistaken, but apparently it went to blah, blah, blah 6 instead of blah, blah, blah 4. And
Okay. Let's see if we can figure it out. Mr. Ham, did I take it Ms. Harvey missed a court date?
Yes, Your Honor, she is pleading arraignment on February 23rd, 2024 before Judge Morrison.
And do you have the notice that was sent out there?
Apologize, I'm trying to stay muted when I'm not speaking because of my background noise, but yes, Judge, I do have the notice that was sent.
Okay, where was it sent?
It was sent to 7376 Poppy Way, Union City, Georgia, 30291.
Okay, and that was returned, and what's, good morning, Ms. Harvey, is that your address?
That is not her address.
Okay, so, I'll need for you to get the clerk your updated address. So was Poppy Way ever your address?
Excuse me, sir. I'm the one who called the police. I gave them the correct address. I gave them on the citation. It's only 7374. There's no 7376.
Okay, so I'm trying to get the correct address, Ms. Harvey, so that your daughter doesn't miss court again, okay? So
Yes, sir.
apparently we have it in the system as one thing. I want to get the correct address so that the clerk's office will have that in the system.
Okay.
Okay, so what is the correct address?
7374 Poppy Way, Union City, Georgia, 30291.
Okay. It looks like there was an error in the address. We have the updated address at the present time. Again, a bench warrant was issued. I'll set that bench warrant aside this time. You will get notification of your next hearing date, Ms. Harvey.
Thank you.
All right. And again, Mr. McLean, if you can prepare that for the court, we'll get it signed.
Yes, Your Honor.
All right, you all have a good rest of your day.
You too.
Position number 3 is Deshaun Shelton. Mr. Shelton with me?
Yes, sir, I'm here.
Okay, yes, good morning, Mr. Shelton. Let's see. Mr. Ham, I take it that and have you spoken with, who's the person that you haven't spoken with?
This is the person that I have not spoken to.
Okay, all right, so, can you put your number in the, do you need this number, Mr. McLean?
I do need his number.
Okay.
I can say something. That's That's my number. My wife turned my phone off the day Thursday after I came from the courthouse with the bonding company, and she turned my phone off. So
Okay, so you have a phone that you're on now. Can you put that number in the chat so that Mr. McLean can call you?
yeah, this is the number, but I can't make no calls out. I'm on Wi-Fi. I only can get into the Zoom.
Okay, so we'll let you get off the Zoom and talk to Mr. McLean, and then you can jump back on, okay?
Okay, yes, sir.
All right, so
Your Honor, I was wondering, is he saying he can't make a phone call even if he does that?
Yeah, I can't make a phone call.
okay, so let's come back to Mr. Shelton, and I'll put y'all into a breakout room, okay?
All right, thank you.
All right, so we'll come back to you, Mr. Shelton. Position 4 is DeAnthony White. Mr. White, good morning.
Yes, sir. Hey, how you doing?
I'm doing well, thank you, sir. Let's see, Ms. McConkey, I take it that Mr. White missed the court date?
Yes, it looks like he missed a court date on June 7th, 2024.
Okay. All right, so you were supposed to be in front of me on June 7th, Mr. White. What was the issue, Mr. McLean?
Let's see, Mr. White, I'm looking at the page on which I don't have my notes on him. Mr. White, I believe you had a very, very brief explanation as to how you missed court. What was it?
I'm currently in between homes right now, and I'm going through something. But I had two different, it was like two different court dates, I believe. One person was telling me I missed one for March 15th, and the one that I was aware of was for March 8th or March 7th, I believe. But I contacted the state court representative, and somebody informed me actually that my case was dismissed. So it's a lot of things that's circulating around this case that is sending me up into spirals, because as you can see, Judge, I've been dealing with this case since 2019. This is not something I would want to play with. I have been losing jobs because of these job opportunities, and I was wondering to resolve this as quick as possible, but it's just a lot of negativity circulating around.
His notice was returned for the 5/21. It came back 5/21.
How did you miss court, sir?
Apparently his notice was returned, Mr. McLean. Mr. White, do you have an address where you can get notice?
Yes, sir. The same address that that you guys have.
Okay.
I believe it's the 2370.
What address did it go to?
They went to 2370 Metropolitan Parkway, Southwest Apartment.
Correct.
Michael 1, Atlanta, Georgia, and it was returned.
Okay.
Did
you hear?
Why did I hear it?
Yes, it was returned to sender.
My mother, that's my mother's address. It's a mailbox. It shouldn't have been returned. I don't know what it had.
Okay.
Do you have a good address in your
Is the apartment number correct?
What apartment is it?
Yes, M1, correct?
M as in Michael 1?
M1, yeah, correct. Correct, ma'am.
Okay, so you didn't, it came back for some reason, Mr. White. Let's see.
So is that my fault?
No. I'm going to set aside the bench warrant. I think that I signed this bench warrant because you didn't show up to one of my court sessions, Mr. White. So I want to get him placed back on a calendar. Mr. McLean?
Yes, sir. Yes, sir.
And if you could, I'll try to make a note also that we place him back on a calendar. And I want to give him a date certain so that, do you have his phone number, Mr. McLean?
I do, Your Honor.
Okay. So I'll set aside this bench warrant, Mr. White, because for some reason your notice came back. And I'm going to have you placed on another calendar here in the very near future. Once I do that, I'll have Mr. McLean also call you to let you know when that court date's going to occur. Okay, I'm going to reach out I'm gonna reach out to my Orca staff today to see if they can reset you on a calendar, okay?
All right. All right. Thank you, sir.
One thing, Mr. White, to make
Yes, sir.
to make doubly sure, even though my cell phone isn't working because of the metal in the building, I can't get a signal. Would you please text that phone number at which I reached you as a reminder to me? Would you text it to 770-842-5471 as a text message?
Say it again.
770-842-5471.
5471.
Right, because my notes on you are over there at that podium.
And you said text my number?
Text your number to me as a reminder to me.
Okay, I got you.
Thank you. I think
I just sent you that text.
Very good, thank you.
All right.
Thank you.
You have a good rest of your day, sir.
Thank you, Judge.
You're welcome. Position 5 is Vicky Williams. Good morning, Miss Williams. Let's see, Miss McConkey, I take it that Miss Williams missed a court date.
Yes, it looks like she missed a plea and arraignment calendar on June 18th, 2024.
Richardson, okay. Okay, Mr. McLean.
Let's see, Miss Williams, I believe, is this the first time you've ever missed the court date?
You have to unmute yourself, Miss Williams. We can't hear you because you have to unmute yourself.
I got it.
Okay, there you go. And find a steady state.
Okay, I'm sorry. I had myself steady. I kind of panicked because I didn't know how to. Okay, hold on. Let me put it back right.
Okay, I understand.
Okay,
that's one where our argument to the court was going to be that whatever mistake she made, it was her first time mistake and she won't repeat that.
Well, I need to know what the mistake is so we can try to rectify it. Do we know, why did you miss court, Miss Williams?
Okay, I no longer live at that address. After I was released, I never returned to that address. And as soon as I got my new address, I started reporting it on, as the young lady said before, I had pretrial. And I started putting it on that form. And I also filled out a forwarding address. But when I got the notice from the courts, it was 2 days after the court date. And so when I got it in the mail, so I called my officer, officer, and she told me that everything would be okay to just go down there to the clerk's office and give them the right address. And I did. And that
Okay, let me see what address we have.
You have the address that she's supposed to stay away from, which was 5321 Hensley Circle at Atlanta at that time. And she came in and updated for this calendar. So it probably was forward to that previous address, but we didn't know.
Okay.
So we didn't get no return.
What is the address that we have that we will send her notice to at the present time?
We have 661 Providence Place, Southwest.
Is that you, Miss Williams?
That is, that is.
Okay, so given the circumstance, I'll set aside this bench warrant. We do have apparently the correct address in the system, so you'll get notice of your next hearing date. So you just need to continue to check in and check with pretrial to make sure that you don't miss another date, okay?
Okay, so she told me that I was no longer, she released me from pretrial. I don't know if I need to check in on that because when I called her that day, I guess because I did everything, I did a class or whatever, and I reported every month. So she released me from that. I'm not sure if I should call her.
Okay, no, just make sure you check in with the court from time to time to make sure that you don't have a hearing date coming up, okay? But
okay, all right.
We have verified that we have your correct address in the system, okay?
Okay, thank you so much.
All right, have a good day, Ms. Williams.
You as well.
All right, so let's go. I think that completes all the bench warrant cases. Can we go back to Mr. Shelton's case and place courtroom 2 and Mr. Shelton into a breakout room?
Very good.
Okay, and while we do that, I think that we're back with, so if we can, the Zoom user and courtroom two into a breakout. Ms. McLeod, who are you speaking with?
I have spoken with Mr. Harvey Horner.
Mr. Harvey. Who do we have in medical there?
Mr. Harper, I'm sorry, I said Mr. Harper, Zion Harper.
And what are we doing with
And I
Mr.?
also, I'm sorry.
What are we doing with Mr. Harper today?
Mr. Harper, we are going to also reset to next week because he tells me that he may have other misdemeanor cases other than these two that are on the calendar. So he wants to make sure that all of his misdemeanor cases have been put on so that they can all be resolved.
Okay, so, Mr. Ham, do you know if Mr. Harper has any additional state court cases?
He does not. He has felony
not.
cases. Doesn't have any additional state court cases.
Okay, so that is all. Okay.
So you still want to reset it for next week, Ms. McLeod?
Yes, Your Honor, because he does have other holes, so he would not be getting out at any rate, and it's not a complete time served case.
Okay. So
I
Mr.
also
Harper,
have Miss.
okay,
I'm
let me
sorry.
finish up with Mr. Harper first. Mr. Harper's positions 14 and 15. We'll reset you, Mr. Harper, until next Tuesday, 7/9. Okay? All right. And who was your other client, Ms. McLeod?
Mr. Kelly, he just got up, but he needs to come back, Mr. Kelly.
Oh. So this was not Mr. Harper. Mr. Harper.
Was the other gentleman
Oh,
who
okay.
put his head in? Yes.
Okay, and this is Mr. Kelly?
Correct.
Yes, Your Honor.
Okay.
And this is going to be a non-negotiated plea, Your Honor.
Okay, so Mr. Kelly's positions 18 and 19.
Yes, Your Honor.
Good morning, Mr. Kelly. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can place your hand down. Ms. Tyson, are you with me? If so, can I have Mr. Kelly's history, please?
One moment here. Looks like we have 28 arrest cycles beginning in 2008. His last arrest was in June of 2022, and that was for criminal damage to property. In the second degree, there's no disposition, and that was in Fulton County. I apologize. In Fulton County, no disposition is listed for that case, Your Honor. Let me check and see if it's pending. Yes, let's see. Says that it's closed. Let's see. One moment here. I'll come back to it. Let's see. He has a felony conviction out of Fulton County for 1, 2, 3. It's like 4 counts of aggravated assault from September of 2019. He has a case out of, let's see, another case was dismissed. He has another felony conviction out of Cobb County for possession of cocaine. Disposition date on that case is October 2018. He has a misdemeanor conviction out of Fulton County for marijuana possession less than 1 ounce. That's from March of 2017. He has a failure to appear 2024 and from 2016. And it looks like he has 2 from 2016. Another misdemeanor conviction out of Cobb County for abandonment of child. Disposition date on that case is August of 2016. He has another failure to appear from 2014. And he has at least 4 violations of probation in the last 10 years, Your Honor. Let me check one thing. Let's see, I'll try to get the case number and see if that case was that felony, was it criminal damage to property? Give me 1 second. I'll check and see if that was a conviction or not. It's not telling me here.
Okay. Mr. Ham?
Yes, Your Honor. In addition to the defendant's history in this case, the facts of this case are as follows. The defendant went to lie on the couch during a verbal argument she had with the defendant in this case. The defendant stood over her and struck her in the head, leaving a large welt above the eye. And this was done in the presence of their 18-year-old son who witnessed the event, Your Honor. So, due to his history, he does have a history of battery, family violence. We have a 22 case out of DeKalb County. Based upon his history and the alleged incidents that happened in this particular event, the state is asking on position 19. Position 19, 12 months to serve 60 days, credit for time served 10 days, the balance to serve on probation, to complete a family violence intervention program, to complete 40 hours of community service, to have no further contact with Whitney Sanders, and to stay away from 235 Peyton Place Southwest. As it relates to the cruelty to children in the 3rd degree, the state's recommendation is 12 months to serve 60 days, credit for time served 10 days, balance to be served on probation, and to complete a parenting course. As it relates to position 19, the state will move to the non-prostate position.
Okay, the battery family violence in DeKalb County, do you know if that was a different victim or the same? You're on mute, Mr. Hams.
I'm not sure, Your Honor. I'm looking it up right now.
Okay. And
that
Ms.
criminal damage to property in the 2nd degree was a felony conviction, Your Honor.
Okay, and the aggravated assault charges of 2019, have those been disposed of, Ms. Tyson?
One moment, let me go back to it. Yes, it was their felony. It was a felony conviction, September 2019 in Fulton County. Yes.
Okay. Ms. McLeod?
Yes, Your Honor. This incident happened approximately 4 years ago, Your Honor. According to the warrant, it happened in July of 2020. The alleged victim and my client, they share 4 minor children. The children's ages are 12, 8, 7, and 6. My client tells me that they do not live together, but they do share these 4 children. Part of what the state is asking for is no further contact. That would be a little difficult considering the fact that they do share 4 minor children. So my client would prefer, of course, no further violent contact, even though they don't live together and they are not in a relationship anymore. They do share these children. So that is obviously an issue since he's still their father. Those are the only children he has, and she's the mother for all 4 of them. The other issue is his job. He's working, because he has to take care of these children. He tells me he works for a moving company. He believes that if he gets out, he can, go back to work. We are asking the court to consider giving him time served and with all the other conditions that the state is offering. Or big issue is the amount of time, because it's going to be a real setback for him if he has to spend all of that time in jail. And as I said before, that incident that we're here for happened in 2020, 4 years ago.
Okay. Has your office been in touch with Whitney Sanders, Mr. Ham?
No, Your Honor, we made attempted contacts to reach her, but we have not been able to speak to her. The state will note that even though this happened in 2020, he has subsequent convictions for violence after this incident happened, Your Honor.
Subsequent convictions, but that doesn't mean that the alleged incident happened after this one.
Okay. Anything further?
Nothing further, Your Honor.
All right, given the age of the case, I'm gonna have him do I'm gonna have it be 12 months to serve, 20 days credit for time served, 10 days. The rest of the recommendation, but I'm gonna increase the community service from 40 hours to 80 hours. Okay?
Thank you, Your Honor.
All right. Mr. Kelly, it's my understanding that in case 22 CR 003331E, you wish to plead guilty to battery, family violence, and cruelty to children in the 3rd degree. Is that correct?
Yes.
And let me make sure, did I swear you in, Mr. Kelly?
Yes, sir.
Okay. Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept your plea, Mr. Kelly, for the battery, family violence. It'll be 12 months to serve, 20 days, credit for time served, 10 days, balance probated, family violence intervention program, 80 hours of community service, and no further violent contact with Whitney Sanders. For the cruelty to children in the 3rd, it'll be 12 months to serve, 20 days, credit for time served, 10 days, balance probated, and a parenting class. I'm going to have you be on probation for the entire 12 months. Anything further on Mr. Kelly?
Nothing further, Your Honor, except I would ask that the court would consider waiving the first 3 months of fees for him since he's been locked up.
Well, you've told me that he has a job to get back to, and given that that's one of the reasons that I'm allowing him to do community service over serving more time, he should be able to pay the $49 in fees per month. So, all right, good luck to you, Mr. Kelly.
Thank you, Your
$39,
Honor.
right? Okay, let's see. Anyone else that,
7? I'm sorry, Judge.
no, you're fine. 7?
Yes, sir.
Okay. And this is Mr. Chestnut. Ms. Tyson, what is Mr. Chestnut's history?
Your Honor, that would, oh, I'm sorry. Apologize.
No, you're fine. I know there was a request for a NOLO. Given that, I want to see what the history is. Are you with me, Ms. Tyson? Okay. Yes, Mr. Ham. Mr. Chestnut, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can place your hand down. Thank you. Mr. Ham?
Yes, Your Honor. I just have one prior conviction for DUI out of 2010 out of Gwinnett County, Your Honor.
Okay, I'm not inclined to consider a NOLO, Mr. Dodd.
You want to go ahead and proceed with the guilty plea? with the terms? It was on mute.
Can you unmute medical, please?
I had background noise, that's why I didn't unmute yet.
Okay.
Mr. Chestnut, the offer is still the same. So if you want to take it, you'll have to plead guilty, but the offer is still the same. So you want to do it?
Yeah, I want to take. Hey, I just want to add, you said it was 240 community service hours?
Yes, 240 hours community service.
I want to ask, can I get less community service? Because I have a job, I also own businesses, so I want to see if I can get a little bit less community service.
I'm not inclined to drop the community service. That's what is standard for everyone, Mr. Chestnut.
Okay, I understand.
Okay. Yes, Mr. Ham.
Yes, Your Honor, for count one, reckless driving, that will merge into count two, which is DUI, less safe. State's recommendation is 12 months to serve 28 days, credit for the time served 14 days, balance to be served on probation, to complete an alcohol, drug, and evaluation and any treatment that's necessary, to take a risk reduction class, to pay a $600 fine, to complete 240 hours of community service, and to complete one victim impact class. For count three, failure to maintain lane, the state's recommendation is 12 months to serve 28 days, credit for time served 14 days, balance to serve on probation, to run concurrent with count two, and to pay a $250 fine.
Okay. Mr. Dad?
Honor, for purposes of the plea, we stipulate as far as identity, factual basis, and venue. I would point out, Judge, that I just got an opportunity to speak to Mr. Chestnut. Obviously, my representation was very limited because he had private counsel up until the attorney withdrew. But I spoke to Mr. Chestnut, I communicated the offer to him. He has been in continuous custody since June of 2022 in DeKalb County. He resolved that matter. I think he got a bond and he was transported here. So based on those, Mr. Chestnut is needless to say, he wants to move on and get out. This is a DUI from 2018, Judge.
Okay. Mr. Chestnut, it's my understanding that in case 19 CR 004086Y, you wish to plead guilty to driving under the influence of alcohol, less safe, and failure to maintain lane. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yeah.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
I understand.
Has anyone forced or coerced you to plead guilty?
No.
I will accept the plea as negotiated. Mr. Chestnut, let's see, when you complete the terms, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't have to report to probation, okay?
Yes, Your Honor.
All right, good luck to you, sir.
All right.
Judge, give us a moment. We gathering up the other inmates, so
Okay.
give me a moment. All right.
All right. So let's go back to the DV bench warrant calendar. I believe that we were on position number 3, Mr. Deshaun Shelton. Mr. McLean, did you have the opportunity to speak with Mr. Shelton?
Yes, Your Honor. He had some movement between when he got arrested and then he went to his grandmother's house. And then at some point, what he's described to me is sounds identical to the idea that a no further contact may have been changed to no further violent contact, and got back together with his wife and everything's okay now as far as the home situation goes. In the meantime, he switched jobs this spring from, and now he's working at a place in Lithia Springs. I conveyed to him the offer, which is part of when the state does send an offer for us to convey, even when we're doing a BW warrant calendar. But Your Honor, it may be best this time for him just to continue to get ready for trial, to hire private counsel while he's working that job full time. It is a good job. And he'd like to ask the court to set aside his bench warrant apparently he, with all this moving back and forth with the grandmother's house, he has a good address now, and it is basically behind the city hall in Union City, about a street or two away.
And he's updated the court with that new address?
Have you told the clerk of that Forest Avenue address?
Yes, sir. I did that Wednesday with my bonding company when we went down to the courthouse.
Okay,
6145 Forest Avenue.
correct.
Yes, ma'am.
That's a house or apartment?
House.
That's a house.
Okay.
Okay, and what court date did he miss, Mr. Ham?
He actually missed the jury trial calendar court date on June 16, 2024, before Judge Taylor. So apparently this was set for trial and he failed to appear in the trial calendar court.
Say it again, the last part?
It was set for trial and he failed to appear on the jury trial calendar call.
Oh, okay.
And do you have a public defender, Mr. Shelton?
No, sir. I haven't talked to anybody since last year, December.
It has Miss Cook, Tanisha Cook.
Tamisha Cook, okay. Well, you need to get a hold of Miss Tamisha Cook as soon as possible, because it looks like you're about to go to trial soon.
Okay.
Oh, by the way, Your Honor, if we took a quick break, I would like to talk to Mr. Ham for a second on the cell phone. I could call him.
On this case?
Yes, Your Honor.
Okay.
Right in the middle of what we're doing here.
All right, so let's see, let me finish up with what we were doing on this, as far as we will set aside this one time. Mr. Shelton, you have to make sure that you keep the court updated with your address. It won't be set aside a second time. You understand?
Yes, sir.
All right. Okay, so we're waiting. Do you need to, you want to call Mr. Ham?
Yes, Your Honor. I can just put myself on mute here. I can mute and run over to the phone.
Okay.
Thank you.
You want Mr. Shelton to stay on the line with us?
It's up to Mr. Ham. I'm just going to call his cell phone and chat for a second.
No, I'm talking about Mr. Shelton here. Do you want him to stay on the line?
Yes, Your Honor, I do.
Okay, all right. So if you'll stay with us, Mr. Shelton, until Mr. McLean comes back and makes an announcement, okay?
Yes, sir.
Thank you. All right, court will be in recess until we hear from someone else.
Position number 4, Andrews.
Okay, Your Honor, thank you for that opportunity. I spoke with Mr. Ham and we don't have a plea at this time, but I'll prepare a set aside.
Okay, all right, so let's see. So Mr. Shelton is free to go this morning. You have a good rest of your day, sir.
All right, thank you.
You're welcome. And what position is this, medical? I'm sorry.
Position 4, Andrews.
Okay.
I believe his mom is on Zoom with us. Is it Miss Chris, CRISS? Or did she drop off?
Right.
No, this case involves some issues that should be confidential.
So, I issued Mr. Andrews a bond on June 18th. I asked that he be placed on his calendar. We didn't have, I wanted him to have a social worker visit at that time, and I also wanted him for you all to have time to get in touch with his mother, Tina Chris, because I didn't want to release him without just release him without having a place that he could reside. Have you had the opportunity to speak with Ms. Chris?
I spoke with Miss Chris, but I think the problem is that she thinks, although I did not discuss that issue with her specifically this morning, I think the problem with her dropping off the Zoom is probably because she was at work, and so she knew that she'd be on or off and periodically. Your Honor, I think that she feels it would be best, according to him, he has heard that it would be best if he didn't live at her home at this time, and he has a proposal for where he would live.
Okay. Hold on, Mr. Andrews. Mr. Ham, if you can remind me of the facts of this, please.
Yes, Roman, once again, this is a.
Your audio is low.
I'm not sure what's going on with my audio today.
Okay.
So, Your Honor, this case involved an incident that happened on May 15th, 2024. Police officers were dispatched to 950 West Peachtree Street in response to a robbery that occurred at the Authentic Brazilian Wax. When they made contact with the person who was at that location, she indicated that the suspect had just left the scene. She left the description, or she gave a description of what that person was wearing. Police were able to find out who he was and indicated that it was actually, in fact, this defendant. And indicated that the suspect entered through the back door of the business and began looking at the beauty supplies on display. And then he started to place it in his bag and to walk out without paying for them. The owner of the location tried to stop him from leaving the location. They had they tugged over the bag, and they landed over the couch in the front lobby. At that point, the defendant started to strike the owner of the store in the head to make her let go of the bag. At the time they came to hold him, but he was able to get loose and walk away with the bag he brought into the store. Approximately was $281 worth of makeup that was taken.
Okay. And At the SCA calendar, Mr. McLean, I granted him a signature bond through pretrial level 1, but one of the conditions, or two of the conditions, one was that he have a social worker visit, and the second was that he was to be released to his mother, Tina Krisk. I guess that, do we know if he had the social worker visit?
I don't know, but he named to me his social worker at PAD, but I don't know if he had a social worker visit yet from ours.
Okay. Hold on, Mr. Andrews. I'm gonna let Ms. McLean speak for you. So what are you requesting, Mr. McLean?
Well, since at the time he told me it was like late afternoon, I didn't get hold of Pat in time for them to be on Zoom today. If we could reset this so as not to delay, I hate for him to miss out on the idea of a signature bond. But he wants to sign himself out and use PAD for his housing.
Okay, he's adamant that he wants to speak, Mr. McLean. Do you need to?
Mr. Morrow, how are you today, sir?
Very brief, Mr. Andrews, please.
Heard. Mr. Harris, which is, I guess, was my attorney, the social worker, he did come and see me at the jail. Jamel Harris, he works for Fulton County. He came and saw me already.
Very good.
As far as my mother, so I did have my social worker visit already. My plan was that I did make contact with, I'm in a program also to Fulton County called PAD. And
Right.
so what I was proposing was that the signature bond that you already granted me or whatever, my mom and me just felt like it would be better for me to just sign myself out and I could take myself. PAD granted me another hotel voucher. So when I get out today, if I am granted a signature bond where you let me sign myself out, I will go straight to the hotel or whatever. They already gave me, her name is Tracy Crawford. We have her contact information or whatever. And I have an upcoming appointment at Rivers Edge to get my mental health medicine and stuff. I have a follow-up appointment coming up and it was for this Friday. So if I'm out, I could be able to make it there or whatever.
Okay.
And that was what I wanted to do. At the time when this happened, I was just having an episode.
Thank you for being brief. I appreciate that. Thank you.
Yes,
So
sir.
if we can get him released to PAD, my concern, I guess, at the SCA calendar was that I didn't want to just place him back out without having a place to go. Ms. Tyson, do you have something?
And he's under pretrial services also on another case, and that he'll still be supervised for the other case as well.
Okay, thank you.
Mhm.
So you check into getting him released to PAD, Mr. McLean?
Yes, sir.
And if I don't want him to, once you do that, then you can get me the order saying that he's been released to PAD. As opposed to what I have, it'll be the same order. I guess you could just update it.
And I believe Pat will come to the jail and pick him up. So we'll get
Okay.
hold of Tracy and get that going. And
Okay, so check into doing that for him and see if we can get him released to them as soon as possible.
thank you.
Okay? All right, good luck to you, Mr. Andrews.
What do we do on your relationship?
Medical, can you unmute, please?
Mr. Morrow, I said, what, but my appointment was on Friday. I said, so what I'm asking or whatever, can I sign myself out today?
Well, we're trying to get
hold of Pat.
we're trying to get hold of Pat, so if we can get that done today, then you'll make your appointment, okay? I understand what you're saying, Mr. Andrews. I want you to make that appointment as well, okay?
I just want to, yes, sir, that's what I'm saying. I just want to be able to Mr. Morrow, what I'm stressing to you is that I can do this for myself. I'm competent and capable enough to whatever. Like where if you let me release, I'm already on pre-trial with Officer Woods. Like if you my attorney, he has my mom's information. Like she's gonna keep in contact with me. You can trust me. I can sign myself out. Is what I'm telling you. Like, I'm gonna let you go through PAD, okay? So, and I'm asking Mr. McLean to get that done today and, get me an order to that effect so I can get it signed so that you can get out as soon as possible. Okay? All right, I don't want you to miss that appointment either. So if I don't get out today, then when will I come back to see you then? Like, I mean, because it seems like I feel like that nobody and I don't know if y'all don't trust me enough to do this, but I don't want to keep stressing you about it. But I'm just saying,
Mr. McLean, I want you to get in touch with with Ms. Lewis today to make sure that once you get in touch with PAD, that we put this on the top of the list, okay?
We will, Your Honor.
Okay, so he's gonna get back in touch with me. I'm gonna have Ms. Lewis get back in touch with me if something falls through. And hopefully it won't, but we'll go from there. But he'll be in touch with Ms. Lewis, who'll get in touch with me, okay?
Is my mom, is she still on Zoom or
Apparently
No,
not.
no, sir.
She was at work.
Okay. All right, good luck to you, Mr. Andrews. Thank you. All
Thank
right, so are we clear, Mr. McLean?
We are.
Okay, very good. Anybody else that we can take?
Number 30, Milton.
Okay,
If you don't.
and this is going to be a negotiated plea.
It is, Judge, and Mr. Melton requested a NOLO plea, Judge. I believe he's eligible. But all the terms are fine.
Okay, what's his history? Ms. Tyson?
One moment, Your Honor, I'm pulling it up right now.
And while you do that, good morning, Mr. Milton. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, I do. Good
Thank
morning.
you. Good morning. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, Mr. Milton.
All right.
All right, we have 15 arrest cycles beginning in 2009. His last arrest was in Cobb County, February 25th of 2022, and that was for a failure to appear. He has a misdemeanor conviction out of Coweta County for a driving while license suspended or revoked. That's from May of 2022. He has another misdemeanor conviction out of Cobb County for DUI. And that's from March of 2022. He has a felony conviction out of Troup County for driving while license suspended or revoked fourth or subsequent offense. And that's from May of 2019. He has a another misdemeanor conviction out of LaGrange, and that's for driving while license suspended or revoked. That's from February of 2018. He has another driving while license suspended or revoked from 2017. Let's see. He took a NOLO plea on a driving while license suspended or revoked in 2017 out of LaGrange. He has another misdemeanor conviction out of LaGrange from, let's see, 2010. So that's outside the 10-year period, Your Honor. Nothing to add.
Okay, Ms. McConkey?
Yes, Your Honor. Are you ready for the state's recommendation?
Yes.
Okay, the state's recommendation for count 1 is 12 months, and that will be concurrent with count 3. The state's recommendation for count 2 is 12 months, and that will be concurrent with count 3, along with a $300 fine. The state's recommendation for count 3 is 12 months, serve 30 days, credit for time served 15 days, balance probated, no further contact with Tara Scott, stay away from the Wesley on the Beltline leasing office, and 40 hours of community service.
And can you give me the facts, please?
Yes, the defendant got into a verbal dispute with the leasing staff of Wesley on the Beltline and then proceeded to tell staff members that he was going to beat them up. The defendant was previously given a criminal trespass from the leasing office on March 19th of 2024. Ms. Tara Scott, the leasing manager, and an officer went to the defendant's apartment to issue the second criminal trespass to the defendant. The defendant became upset, started screaming and cursing at the officer and Ms. Scott, and then threw a raincoat at Ms. Scott and then threatened to harm her in front of the officer. Upon being placed into custody, the defendant snatched away from the officer several times and also spat in the officer's face.
Okay. Mr. Dodd?
Your Honor, the reason for the no plea is Mr. Milton relates to me that he's had issues with that officer who has a history of harassing Mr. Milton. I did explain Mr. Milton does reside at that residence, but his apartment is on the other side of the leasing office. So what I explained to him, as far as any payments or anything like that, he'll have to submit that with just a money order to be mailed and not to have any contact with the leasing office. There's no reason for him to be at the leasing office at all. But
Okay.
I would ask the court to follow the state's recommendation.
All right. I'll allow him to use his NOLO.
Thank you, Judge.
Mr. Milton, it's my understanding that in case 24 CR 003942J, you wish to plead NOLO to criminal trespass, willful obstruction of a law enforcement officer, and terroristic threats and acts. Is that correct?
Your Honor, as far as the terroristic threats, okay, so number one,
Hold on, Mr. Milton. You have a right to remain silent. Anything you say can be used against you. Okay, so I'm happy to let you speak with Mr. Haddad about any of that, but
we did, but I work in banking.
okay, but hold on for a second. Just let me say that what you say might affect the sentence that I give you, or even if I allow you to plead NOLO in this case. Okay, so that's why I'm happy to let you speak with Mr. Haddad if you need to speak with him about something. But if you say something to me that I can't unring the bell on, then although you do have a right to remain silent, it might not be in your best interest. People always want to tell me something, but oftentimes it comes around to not be in their best interest.
Honor, if I may, I think one of the contentions of Mr. Milton was any effect on his employment, and I mean, what I told him is the employer is going to do what they do. I mean, based on the history from pretrial services, he does have a history of convictions. I'm not sure that this particular case is really going to make a difference, but hence the NOLO plea as well, Judge.
Okay, so it's up to you, Mr. Milton. If you could unmute medical for me.
Yes, sir. As long as I was stating, as long as the terroristic threats, if I can have it somehow deplenished from my record, I don't have any violent charges. I work at BOA, which is the #1 bank in the world. And if I have terroristic threats on there, it might risk my financial situation as far as me obtaining another job. Right now, I am in PAD, and as she stated, the FTAs and all that stuff, it was because I made a deal with the Fulton County Public Defender Office. If I was to stay in jail and get myself together and get in the program, which I did graduate, and I haven't been in trouble in 2 years. This is the longest I've ever stayed in trouble since obtaining a criminal background. And that's been showed inside of the criminal history. I haven't been in trouble since 2022 because they put me in a program, and I graduated the program and obtained housing, which I am in now at the 370 Northside Drive. I did not cause any harm. The only harm that I did cause, and I do admit to that, is when they came to my home. If I'm banned from the leasing office, that's the leasing office. Don't come down there. You already gave me a ban in March. I received that. So why are you coming to my home in the prior month and giving me another one? So I did get angry. But as far as terroristic threats, I mean, that's something serious. I don't have any history of violent charges. I don't do the only thing you ever heard, driving. That's the only thing I've ever done. Driving. Yeah, I was hard-headed when I was little. I had a car. I owned a car. So you got keys. You want to drive when you're younger. I don't have any violent charges. I don't need that on my criminal history. So with me saying all that, if it could be somehow, if I finish the probation or something, could it somehow be wiped away from my criminal history? Because I worked too hard, and then I'm in medical school. I have 4 more months before I finish being a medical assistant in College Park at Clinical Skills Training Center. So with that, banking and medical, the first thing they're gonna look at, and they don't have to say it, but they see that terroristic threats, I'm gonna look like, you know, I can't uphold a job in a white collar community.
Okay, I can't advise you on what to do, Mr. Milton. So
I'll take it, Ron.
I am, allowing you to plead no to the charges, so it's up to you.
I'll take it. Run my life.
Okay, so it's my understanding that in case 24 CR 003942J, you wish to plead no to criminal trespass, willful obstruction of a law enforcement officer, and terroristic threats and acts. Is that correct?
Yes, ma'am.
Is that a
Can I
yes?
get out today, Judge, if I do all that?
It is a time served plea. You will get, if you don't have anything holding you, you will get released as soon as you get processed out by the jail. What do you want to do, Mr. Milton?
Go ahead. Do what y'all want to do. Go ahead.
No, this is doing what you want to do. So my question was are you pleading no to criminal trespass, willful obstruction of a law enforcement officer, and terroristic threats and acts? You have to, and that's a yes?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Well, I take mental medication, but I do understand what you all are saying. I'm competent to understand.
Okay. You've been represented by counsel. Are you satisfied with his representation?
I'm very satisfied with his representation.
You understand that you have a right to a trial by jury on these charges, and that by pleading no to them, you're giving up your right to a trial by jury?
Yes, sir, I do understand. And thank you, District Attorney, as well.
Has anyone forced or coerced you to plead no?
No, sir.
Okay, I'll accept the no plea. Mr. Milton, let's see, when you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't have to actively report to probation, okay?
And what all I gotta do now, Judge?
It's a $300 fine. No further contact, stay away from the leasing office, and 40 hours of community service.
That's it.
Okay, so as soon as you get to pay the fine and do the community service, you won't have to actively report to probation, okay?
Yes, sir. And when do I need to report?
You'll be informed of that, Mr. Okay?
Okay, thank you.
All right, have a good day, Mr. Milton.
And you as well. Thank you all.
We have position 13, Mr. Grimes, for Ms. McLeod. We need to do a breakout. Come on, Grimes. Come on.
Okay. So while they're doing that breakout, can we go over the calendar?
Yes, Judge.
Okay, so if we can place medical and Ms. McLeod into a breakout room, please. Yeah, what were you saying, Mr. Dunn?
Judge, I still have one plea, whenever he's brought position number 20 and 21, Andrew Lynch.
Okay, so we'll get to them.
It's a time
But if-
served sentence.
Okay, but if we can go ahead and go over the calendar, so we'll have that complete. Whenever you're ready, Ms. Lewis. Thank you.
Everybody can hear me? Okay. I'm gonna start with the probation revocation calendar, position 1 and 2. The defendant was revoked for 90 days credit for the time he already served. Case is closed out. Position 3 and 4 was commuted to time served, 29 days. Probation is closed out. On the DV counter, all the cases were reset. Final forfeiture was set aside. On the original counter, the regular counter, position number 1 was non-pros. Position number 2 was a plea. Position number 3 was a plea. Position number 4 is reset further notice. Position number 5, waive arraignment, not guilty, reset for trial. Further notice. Position number 6 was a plea that was taken prior to this counter on the previous SAP on 6/27. Position number 7 was a plea. Position number 8, we're still holding.
Okay.
Position number 9 was a plea. Position number 10 was released in case of set further notice. Position number 11 was a plea. Position number 12 was non-pros. Position number 13, still holding. Position number 14 and 15 should be set for the SAP counter for July the 9th, 2024. Position number 26, defendant waive arraignment, not guilty. The case is set for trial per the notice. Position 17, be set for SAP 7-9. Position number 18 was non-pros. Position number 19 was a non-negotiated plea. Position number 20 and 21 we're still holding. Position 22 and 23 was a plea. Position number 24, 25, 26, 27, 28, and 29 are all reset for the SAP count for July the 9th. Position number 30 was a NOLO plea. Position 31 and 32 still holding. Then it's a private attorney. I don't know if he got on or not. Mr. Moore. Not seeing him or his client. Position number 33 was a plea. Position 34 was non-pros. Position 35 was still holding. Position 36 was a plea. Position 37 was a non-negotiated plea. Position 38 was a plea. Position 39 was a plea. Position number 40 was time served. Position 41 was non-pros, and I'm still holding on 42.
On 42, he's refused to come out, Judge. This is the second or third reset. He won't come out of, I was hoping to avoid having to do a competency, but it looks like that's where we're heading.
Okay. I think that last time that this was before me, Mr. Dodd, we said that I'd give him another opportunity, and if not, that you all should consider getting him evaluated.
I'll speak to Mr. Bartels, Judge, and we get the appropriate paperwork. If we can just reset it for, 4 weeks from now, perhaps, I don't know, whatever the courts, the paperwork will be quick. It's just a question whether, obviously the evaluation won't be that fast.
We can reset it 4 weeks out, and you want it to be set on the next CC counter.
Yeah, that'd be good.
What's that date?
It's gonna be, let's see, 4 weeks out. So it'll be August 1st.
Okay.
What position is this? I'm sorry.
Position 42, Craig Washington.
Okay, thank you.
The competency counter for August 1st.
Okay, we'll be in recess until Ms. McLeod comes back.
What about the wrong one, Sean? Anybody got a city? I'm just looking on the other place. I won't vote on one anyway. We're gonna do the family.
Position 13, Grimes, Ms. McLeod client.
I forgot.
Okay, what, I'm sorry, what position?
13.
I'll see you after a while.
When did this house?
And what are we doing with Mr. Grimes?
Your Honor, I will be filing a formal waiver of arraignment for him.
Okay, Mr. Grimes, your case is going to be returned to the division judge. You'll get notification of your next hearing date, sir. Good luck to you.
Thank you, Your Honor.
Position number 35, Robertson.
Okay,
He stated that he hadn't spoken to a attorney yet.
okay, Ms. McLeod,
She verified that they're not her clients.
I already checked you on, and no, Mr. Robbins is not my client.
okay, I'm not sure why I have your name on the calendar.
Oh, you do?
Is there a conflict in this case, Mr. Dodd?
Ms. McLeod,
Yes, I'm here, so I can speak to him.
you filed an entry on this case back
Oh, I
on
did?
June the 7th, 2023. You represent him at the, it looked like you represent him on the SEA counter back on April the 3rd of 2023.
Okay, for some reason I didn't see him on my list of
Yeah,
clients.
yeah.
Okay, no
Okay,
worries. I will
so-
speak with him.
All right, so if we can put Ms. McLeod and medical into a breakout, please.
Position number 35.
Okay, and what are we doing with Mr. Robinson?
This is going to be a negotiated plea, Your Honor.
Okay, good afternoon, Mr. Robinson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Ms. McConkey?
Yes, Your Honor. The state's recommendation is 12 months, served 30 days, credit for time served 15 days, balance probated, and no further contact with Sean Reagan.
Balance suspended?
The recommendation was balance probated, but I have no objections to making it balance suspended.
Okay, so aside from
We were
the,
going to ask for that, Your Honor.
okay, so balance will be suspended. Anything further, Ms. McLeod?
Nothing further, Your Honor.
Mr. Robinson, it's my understanding that in case 23 CR 002038E, you wish to plead guilty to a fray, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Good luck to you, Mr. Robinson.
Thank you, sir.
Next
Your
is
Honor.
position number 8, Elps.
Okay, and this is also going to be a negotiated plea.
Yes, it is, Judge.
Good afternoon, Mr. Epps. Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Can you hear me, Mr. Epps?
Yes, sir.
Okay, and you agree to have it heard by video?
Yes, sir.
Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you. Mr. Ham?
Yes, Your Honor. For count 1 DUI, driving under the influence, that count will merge with count 3. Count 2 DUI, driving under the influence less safe, that count will merge with count 3. Count 3 DUI, driving under the influence of alcohol and drugs, state's recommendation is 12 months, credit for time served 258 days. For count 4, failure to maintain lane, state's recommendation is time served. Count 5, seatbelt violation, state's recommendation is time served. Count 6, possession of open container, state's recommendation is time served. Count 7, driver while license suspended or revoked, state's recommendation is time served. And count 8, driving under the influence of alcohol and drugs, that will merge into count 3, Your Honor.
Okay. Mr. McLean?
That's what we expected to hear. He does ask the court to accept his negotiated plea of guilty. This case is not on his booking sheet. It's just a case that he administratively wants out of his way, but it's not in his way as far as custody is concerned. Your Honor, on the seatbelt violation, I think that's a $15 fine. I don't know if we can call it time served because it doesn't carry time at all, ever. Not a first time seatbelt. So
Okay.
you could waive the $15 fine, that'd be great.
Okay. I'll waive the fine. Time served, waive fine. We can put both of them down. Anything further before I take the plea?
Nothing. We do stipulate for the purpose of the plea to venue factual basis identification.
Okay. Mr. Epps, it's my understanding that in case 21 CR 005718D, you wish to plead guilty to driving under the influence of alcohol and drugs, failure to maintain lane, a seatbelt violation, possession of open alcohol container, and driving while your license was suspended or revoked. Is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up the right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Epps. Good luck to you, sir.
Yes, sir. Thank you.
Okay, you're welcome.
Position 31 and 32, Jacob
Okay.
Patrick.
It's my understanding that there's a private attorney on this case that we've not been able to get in touch with. As such, Ms. Lewis, we're gonna reset the case. We're gonna reset the case until next Tuesday, which will be 7/9. So we'll see you back. Hopefully we'll be able to get in touch with your attorney by that time. It's my understanding that he's not being held on this charge.
He's not.
Do we have anybody else there in medical?
No, we don't have anyone else. We're done.
Okay.
2021 about to be reset too.
All right, so I still have 20 and 21.
Oh, that's medical. I have to go get that person. Stand by.
Okay.
Hey, Judge Morrow, Mr. Patrick want to know what case is this pending?
Andrew Lynch.
No.
Let's not talk about that person. Mr.
He wants to know, I'm not sure what he has pending. Do we know?
Who are we talking about?
The man that we just reset.
Oh, you
as
talking
his
about
attorney.
Commissioner Moore?
Yes.
He wanna know, charges that he have for us. That's what you wanna know?
Yes.
They're on account. January 27, 2022, and another battery case.
They're battery cases from 2022, apparently.
The other one's reckless conduct, discharging a firearm, and theft by receiving stolen property was September 2nd of 2023.
Okay. So can we get those last, Mr. Lynch? I've got to give this court.
I have to get him because he's in. I may have to get authorization to get him because of where he's housed at. So stand by. Let me see what the.
Okay, well,
they say.
let me just say that I've got to give this courtroom up because there's another court coming in here in the next 10 minutes. So is that something we can get done in the next 10 minutes?
Correct. I'll be able to see what's going on.
Okay, thank you.
Basically, it is family issues where my sister's about to put her out and just trying to get everybody from around her. She's already handicapped, she already been shot and stuff like that, so.
Are we still holding for Isaiah Grimes also?
You ready, Mike?
Okay.
That was reset.
Okay. Thank you.
Nothing. He saw it for what? He had no bruises, no marks, no more. So how? And I'm trying to figure my own, my mom calls, so she can see my lawyer. You know what I mean? Where one, she know what type of do, like, he's not.
Mr. Dodd, what is not negotiated about the Lynch case?
We worked it out, Judge. It's gonna be negotiated plea, time served.
Okay, very good. Thank you.
Essentially, Judge, it's stay away from that location.
Okay.
Right, bounce suspended, stay away.
Can you send over that no house on the other case?
What they're gonna do over there is,
I think the 40 hours of community service.
Well, you said balances.
Oh, well,
Time served.
If not,
My mom will eat the bug, no problem.
I'll be off as soon as I can.
I have to get my daughters. He know I have nobody else to get my daughters, and he knows it. He got to get everybody. He got my mom, boyfriend in a situation dealing with DeKalb County. He put a straight order out on my sister. He took her away from my ministers. He just doing all this to keep everyone away from her. And it's nothing I can do. You can go to one of somebody, but he said, she said. It's nothing I can do.
Courtroom number 2.
Right. So what is like talking about, like, what you mean? Press charge.
Soon as he take the plea, I guess you can sign the non-process. So we type, so. Guys, I got to add on. I'll print it out for you.
Of course.
You haven't done that plea yet.
Well, I'll have it done when I do. If not, you just tear it up.
You want me to stay with the other one?
No, I've got it. Thank you.
Mr. Lynch is present.
Yes, good afternoon, Mr. Lynch. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I swear.
Okay, you can place your hand down. Thank you. Yes, Mr. Ham.
Yes, Your Honor. The state's recommendation for position 20 is for disorderly conduct, 12 months served, 26 days, credit for time served, 13 days, balance suspended, and to stay away from 4689 Roswell Road, Sandy Springs. For position 21, the state will move the null process.
Mr. Dad?
Judge, on behalf of Mr. Lynch, we stipulate as far as venue, factual basis and identity. Mr. Lynch, the state's recommendation, they've agreed to give you time served, so we're good to go.
Okay, cool.
Thank you, Judge.
Okay. Mr. Lynch, it's my understanding that in case 23 CR 007087Y, you wish to plead guilty to disorderly conduct. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir, I understand.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Lynch. Good luck to you, sir.
Thank you, sir. Thank you.
Thank you, Judge.
All right, I believe that completes the calendars for today. You all have a good rest of your day. I'll see you next time.